Hello, hello, hello. This is attorney Mike Gravelin coming to you from Chicago as usual, and we're back. We're back to this wild and wacky case. Let's start this off proper here. Okay, so we had a real intro. Good morning. Good morning. I hope you're all having a nice cup of coffee here. I don't see anything happening in court yet. It's pretty exciting. Let me see. That's the feed right there. We'll keep that up to remind me. So this is pretty exciting. I'm not sure if it's going to go down or not, but I believe we have a chance to maybe have boots on the ground in the courtroom today. Namely, John. John's always in the comments. He was on the stream with me on my daybell with Kurt. And also, we did a big discussion on the Arizona video law. So you know him. As it turns out, he lives in Tampa, and we're going back and forth. Yesterday, he sends me a picture. He's like, "The courthouse is right here." He shows me a picture from his front porch or whatever. He's like, "It's right there." I'm like, "Dude, go over there. Go over there and tell us what's going on in the courtroom in LawTube style." And I think he's going to do it. So that's the plan. I cleared things, so we should be pretty good. The way I see this breaking down, of course, you never know, but the way I see this breaking down today is Mr. Oh, wait, where is he? Where are you at, John? Are you in court? Tell us in the chat. Users coming in 5. I don't know what that means, but that's okay. That just shows that he's in contact. All right. So the way I see this breaking down is he's going to get on and testify, which should be really awkward because he can't. Oh, he's going to be there. That is awesome. Wait. All right, you think he's going to? I hope he testifies. If not, either way, it's good because we've got interesting parts of the case today. If he doesn't, he called his witnesses yesterday, so really the only person to testify is him. And the judge wanted to have this colloquy with him. He said this morning to make sure that he really wanted to testify. Which I don't know which way. You know, he slept on it. Maybe someone talked some sense into him. He has no business testifying. It doesn't really matter. He already sank his ship. My guess is that his ego will just get in the way, and he'll say, "Well, I want to be center of attention for one more day before I go to jail." I mean, you know, I don't know what the jury's going to do, but that's my guess as I sit here. So, you know, I would think that he does that, but if not, then I think he's got to close his case. He's got to rest because there's nothing else to do. He called his other witnesses. He doesn't have any other evidence to present, and even so, if you have evidence, you have to present it through a witness and lay a foundation. And he clearly doesn't know how to do that. I'm just judging that on his refreshing recollection and what's the word I'm looking for? Impeachment skills, which are nil. So anyway, it should either be him testifying or we should go to closing arguments or both. My guess is he comes out, testifies, makes a complete mess of it, but it'll be interesting to watch. Then they will break for a jury instruction conference. I base this upon the conversations they were having in court yesterday. And during that break, I think what I'll do, it depends how long it is, but I'll probably just do 2 separate streams. I'll probably close it down and then do another stream as soon as closing arguments start.
Hope everyone had a nice night. Yes, Mr.
Here we are.
Marquise, thank you.
Action
Good
in
morning.
court. Action in court.
All right. Let the record reflect everyone is present, including Mr. Summers. Good morning to everyone again. The first thing, well, we're going to get to in just a moment. Mr. Summers, I gave you the evening to consider your decision whether to testify or not testify. We're going to get to that in a moment. And we have some time because one of our jurors, I just want to let you know that number 7 is not here yet. That's the same gentleman that was late yesterday. But it's all right. We'll see. We'll address that as that'll be the last thing we address, and maybe he'll be here. The traffic was terrible. It took me twice as long to get here this morning. So I suspect that the traffic is probably the reason for that. But the first thing that I want to address this morning is that I was advised by the clerk's office this morning that for approximately 1 hour last night, the evidence was left in the main clerk's office before it was ultimately moved to the evidence vault. The clerk's office, though, this morning has gone through all of the items of evidence with the list and has verified that all of the admitted evidence is, in fact, accounted for. So I just wanted, since they notified me of that, I wanted to notify you all of that same information. All right? All right?
Why?
All right. So that takes care of that.
That's stuff that happens every day.
Here,
Keep it to yourself.
Great. So things are starting to fall into place. So now, Mr. Summers, I am going to turn to you and address you and your decision whether to testify or not. The first question, actually, I do have to swear you in if you'll raise your right hand because I have to ask you a number of questions. Thank you. Do you swear or affirm any testimony that you may give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. Thank you, sir. The first question that I want to ask you is, did you have the opportunity to consult with standby counsel regarding your decision to testify or not testify in your case?
Yes, Your Honor.
Do you understand that you have the absolute right to remain silent and not testify in your case? The other side of that is, if you wish, you can come down and testify as a witness, just as all the other witnesses have testified. I think I mentioned the procedure to you yesterday. I will follow the same procedure as all the other witnesses. You'll come in front of me. I'll swear you in. You'll take the stand. The only difference is, since you're representing yourself, you won't have someone else to ask you questions. So your testimony will be presented in a narrative form where you can just talk to the jury. If at any time you are presenting testimony that the state believes is objectionable, they would then object, give me the legal basis for the objection, and I would make a decision as to whether you can continue saying that. The issues that may come up are relevance, hearsay, things like that. So,
other words you don't understand.
Much like the things that have come up with other witnesses. At the end of the day, it is your decision and your decision alone whether you are going to testify or not. My next question to you, sir, is, have you had sufficient time to consider this very important decision?
Yes, I have, Your Honor.
Have you made a decision?
Yes, Your Honor.
What is your decision?
I will not testify in this.
Has anyone forced you or threatened you in any way to reach this decision not to testify?
No, Your Honor.
Are you under the influence today of any alcohol, drugs, medication, prescription, or over-the-counter that may in any way affect your ability to freely and voluntarily make this decision?
No, Your Honor.
Okay, thank you. I appreciate. Let me just see. State, did you have anything else that you want me to ask him regarding his decision?
No, Your Honor.
All right, thank you. Thank you very much, Mr. Summers. So that means that you need to rest your case. Again, I can't help you and I'm not helping you, but some of the procedural things that you may not be aware of, in order for us to move forward, I will let you know. That means that you have presented all of the evidence that you intend to present. Do you agree? Is that correct?
Yes, Your Honor.
All right. So that means that we are at the stage where you would rest your case. What I propose that we do, since all of the jurors are here, is that I bring them out. I turn to you. I welcome them. I ask them if they've been exposed to the case, just like I've done every other morning. I then turn to you and ask you or tell you you may proceed. And then it would be time to announce the resting of your case. Then once you've done that, I will tell them that there are legal matters, because we then have to go over the jury instructions, the charging conference that I mentioned, and I asked you to read the instructions last night. So I would then explain to them that now that, well, let me just make sure. I would then, once the defense rests, turn to the state, who has the opportunity, if they wish, to request a rebuttal case. Is there any such request?
No, Your Honor.
All right, excellent. So knowing that, what I may do once he rests, I'll turn to the state. Is there anything else from the state? And you can say nothing. And then I'll tell them, now both sides have rested their case. I have to go over the legal instructions and legal matters with them. I don't know how long that's going to take, and send them out. I know that I don't know how long it's going to take, but I know it's not going to be super short. So I'll leave it up to the bailiffs if you want to let them go to the coffee shop or something like that and come back, since they're going to be in that room for a little bit of time. Is there any objection to that procedure?
No,
Just like when they take a lunch or anything like that, we'll tell them maybe an hour. It may not take that long, but I'd rather that we're done and waiting for them than they're back there waiting for us.
It'll take that long.
That's fine, Your Honor.
Do either of you think that an hour, I mean, I could say 40, let's do 45 minutes. We have to print, so we'll tell them 45 minutes. All right. So they can go for 45 minutes. All right. Is there anything else from the state before I bring them in?
Nothing from the state, Judge.
Mr. Summers, anything from the defense before I bring in the jury?
Not at this time, thank you.
All right. Let's get the jury. Thank you.
Well, there we go. That surprised me. I thought he was going to go for sure.
Say ladies and gentlemen, and then correct myself.
I wonder if he had access to his attorney last night,
The fourth day.
the one he fired, because he stayed there and fell asleep behind him during the proceedings yesterday.
It's cold in here today.
Not yet. It gets colder though.
It's really cold.
By the afternoon, it's freezing.
I needed the paper, so if you could email it to. Yes, we are.
All rise during your courtroom.
Jury is present and seated. Everyone else may be seated at this time. Gentlemen of the jury, good morning and welcome back. I know it's a little bit later than we had expected to bring you in. I do apologize for that. Take full responsibility. I also know the traffic was very bad this morning. I'm not responsible for that, but I was actually part of that myself in that traffic. But thank you all for being here and for being here safely. First thing that I need to ask you is whether any of you, by raising your hand and letting me know, were exposed to anything about this case outside of the courtroom between the time you left yesterday and the time that you returned this morning. Let the record reflect there are no hands. Additionally, I will ask whether any of you discussed this case amongst yourselves or with anyone else between the time you left yesterday and the time you returned this morning, by show of hands. Let the record reflect there are no hands. Again, thank you all very much. So you may recall that we left off yesterday in the defense case. I am now going to turn to the defendant and ask him to proceed.
Your Honor, at this time, the defense will rest.
All right. Gentlemen of the jury, is there anything else from the state?
Nothing further from the state, Judge.
All right. Gentlemen of the jury, each side has now concluded their presentation of the evidence in this case. You may recall from the initial instructions that the next phase is the closing arguments of the attorneys, the state, and the defendant. After the closing arguments is the instruction on the law. I cannot finalize or could not finalize the instruction on the law until all of the evidence was admitted. I am going to excuse you and I am going to finalize the instructions. I'm going to, we're going to take a 45-minute break, and I believe it's my understanding that the bailiff is going to let you go to the coffee shop or anything you want and come back in. And we should be ready at that time and proceed to the closing arguments and the instructions on the law. Please be very careful not to be exposed to anything outside of this courtroom about this case and to not discuss this case amongst yourselves or with anyone else. Again, thank you all very much for your time, your patience, and your service. All rise for the jury. Jury has exited. Everyone may be seated. All right. Both sides have rested. Mr. Summers, is there anything that you want to say or put on the record now that you've rested your case?
Your Honor, would you like to discuss the jury instruction of the abandonment purpose?
That will come. We're going to do a charging conference in just a moment. And yes, we will discuss that during the charging conference. But is there anything else that you want to, and if you want to lean over and talk to Mr. Marchese, I'll allow you to.
I do have a question about the, yes, pardon me. one moment.
Absolutely. Mhm.
So he is conferring with his attorney. I don't see John in there.
Summers, was there anything else? You said you had a question, and I absolutely will get to that question. If you want to ask that question first, you can do that, or if there's anything else you want to do or say at this time.
I'll wait until we get to the jury instructions for that question.
Okay.
But I would, again, move the court for a verdict of acquittal. Your Honor, the defense moves for a verdict of acquittal for failure of the state to prove a prima facie case against me on the first and second charge of premeditated attempted first-degree murder. The state has failed to prove any premeditation. And I add abandonment of purpose. The facts clearly show an abandonment of any attempts. The defense moves for a directed verdict of acquittal for failure of the state to prove a prima facie case against me on the charge of kidnapping. The state has failed to prove the purpose of the kidnapping was for grand theft. And the state has failed to prove any intent to commit the crime of grand theft, the alleged purpose for committing the kidnapping. And on the charge of grand theft, the state has failed to prove any intent to commit grand theft. On the two charges of sexual battery by a person 18 or older and upon a victim 18 or older, the state has failed to prove any intent to commit both counts of sexual battery by a person 18 or older upon a victim 18 or older. I thereby move the court for a verdict of acquittal, please.
All right, let me just give the state a brief opportunity to respond to the motion.
Judge, as far as to counts 1 and 2, the state has shown a prima facie case of premeditation. We clearly have testimony from Ms. Mathewson, who said as to count 1 that he came into the bedroom with the pillow, puts the pillow on her, then gets on top of her and proceeds to straddle her, applying more pressure. As far as count 2, testimony was that the defendant went from the front driver's seat to the third row, got behind her while she was tied up, claiming he needed to write a letter to his parents. And at that point, that's when he pulled the rope and was strangling her. There is no abandonment in this case, Judge. Because he failed to carry out the actions in which he intended to do is not abandonment. I have case law prepared, Judge. I'm ready to go ahead and just argue that if you would like.
Yeah, let's wait till we get to the attempt instruction because that's part of the standard instruction on attempt that includes abandonment.
Ooh, that'll be interesting.
So let's wait till the charging conference to argue that.
I'm kind of looking forward to that.
As far as to the grand theft, Your Honor, it is clear from the testimony that after Ms. Mathewson tried to run away at the Walgreens, the defendant ran out of the store, grabbed her, forcefully put her back into the car and drove away from the Walgreens. There's testimony that for 2 days he was driving around Hillsborough County, Manatee County. That is evidence of him depriving her of her vehicle.
Let me just ask, I apologize for cutting you off, but when you say things that I want clarification on and not sure that I understand, is it your position that the depriving of her was related to the Walgreens and not when they left the house, or that when they left the house, but somehow what happened at Walgreens? I just didn't understand. Go ahead.
Yes, Judge. Starting from the house, because we have testimony that he tied her hands behind her back, puts a blanket around her shoulders, puts her in the back seat or the second row. He's the one who got the car keys. He's the one who drives, and per his own statement with Sergeant Remia, drives to the Walgreens. And then it continued from there. We even have his statement to Sergeant Remia, or what he says to Miss Mathewson is that we can't go see the kids now because of her trying to run away. And at that point, proceeds to drive around Hillsborough County down to Manatee County, Anna Maria Island, finally ending up 2 days later in Little Harbor. And the jury instructions as far as a grand theft of a motor vehicle or obtaining or endeavoring to obtain means either permanent or temporary. And in this case, we have 2 days, Judge.
Okay. What about the other, if you want to respond to the kidnapping, but the sex battery?
As far as the kidnapping, the state's relying upon all the testimony provided. There's an independent witness who saw it happen. Lastly, as far as the sexual battery, it's up to the purview of the jury to decide whether there was consent or not.
Right, but specifically, what evidence are you contending is enough to get past this stage and be presented to the jury?
The fact that he snuck into the house in the middle of the night, he wakes her up, her testimony being that he grabs her by the ankles, pulls her off the bed, an argument, struggle ensues in the living room. Ultimately, once the kids are gone, she's tied up in the bedroom. All of those acts that the defendant took carry along with Miss Mathewson's testimony that the sexual act that took place against her was not consensual.
Thank you. Mr. Summers, any brief response to anything that the state has presented at this time or argued?
Yes, I continue my standing objection to the statement made in the hospital. I do concur that that was something that was not voluntary. And but however, Honor, if they're weighing on that, there are other statements I made in that interview where I never said I intended to kill somebody. I never even mentioned strangulation, if they're relying upon that. Nor did I mention desire.
I never mentioned
intention
strangulation.
to steal a vehicle. I speak about it as a common item that we share, that we use. And I also speak about the sexual encounters as casual. It is something that is a common thing between the victim and I at that time and prior to that. And the victim herself stated that sex doesn't mean that much to her.
I mean, that
I'm not
doesn't
really
mean
buying that, but
someone
it's
who
what you
is
should
of
say.
That position can't be sexually battered just because sex doesn't mean that much to her.
I understand, Your Honor, and I'm explaining to you as best I can without testifying as to the situation at the time. But I can just assert that none of my statements have, whether recorded or not, have led to there to be any belief that that I intended to do that out of coercion, out of desire, out of anything other than just something that her and I agreed to do to pass the time. And aside from that, Your Honor, again, the vehicle, there is no evidence of me needing that vehicle, requiring that vehicle. she attested to the fact that when we go out, I drive. Again, Your Honor, I have not attested to these facts. That the only things they're relying on are a statement that I, again, have objected to. I would also object to their statement that Ms. Summers or Ms. Mathewson stated that I brought a pillow into the room because I don't believe that was presented in the testimony during this trial. I believe that is a statement she made in a previous recorded proceeding, but not during this trial.
Well, that's ultimately certainly something that you can argue to the jury, and I will instruct the jury to rely on their own recollection that what you and what the state says during closing arguments is not evidence, but that they're to rely on their recollection of the testimony. So that's the issue may come up there. But what I want to understand right now is it appears that your legal position is that you never intended to commit the crime of, I guess, murder, and that you never intended to commit the crime of kidnapping. I mean, that's, I think, what I heard you say. Is that correct?
Correct, yeah. There is no intention from her statements or my statements.
Okay, and that is certainly an argument, a defense that you can raise and argue to the jury. But my question to you, it's about to come up in the instructions, is how can you abandon something that you never intended to do? You see what I'm saying? I mean, do you understand that? If my position is I never intended to touch that book, then how can I argue that I abandoned? What did I abandon if I never intended? You abandon your lack of intent to touch. I never intend to do something. How do you then argue that I abandoned? What are you abandoning if you never intended to do it?
Good question.
Your Honor, again, I believe that goes to the legal argument, and if you'd like me to.
It sure
But
does.
your legal position in your motion is that I never intended to do it. I just said, it sounds to me like that's what your position is. Is that your position? And you said, yes, it is. I never intended to do it. So, and I said, and we will, I'm going to deny your motion for a judgment of acquittal at this time. But now we're going to move to the jury instructions. And when we get to the abandonment, I'm curious to see what you say, because now you're going to argue that I don't know what you abandoned if you never intended. So,
May I answer that
sure,
one
absolutely.
question for you?
Yeah, I'd love to hear it.
In my own statement, I never intended to commit murder or intended to murder her. I never intended to kidnap her. But in addition to that non-intention, I add to that the defense of abandonment based on her statements that both times she says, I just stopped. And that is where I add in the factor of abandonment of purpose.
So tell me exactly what you're abandoning.
Abandoning the process of attempting to kill someone.
Process of attempting to kill someone when you never had any intention to kill someone. Is that is that a correct statement?
Yeah, because in the first place, I didn't have the intention. And then the intention is derived by the victim's understanding, not by me admitting it, not by my own desire, not by my own actions. There
Wrong.
are a variety of other reasons why things could have happened according to the way she says they happened. They don't have to all lead to the attempt to murder.
It's your intent,
It just
goofball.
appears to me, at least at first blush, that those are separate defenses. Didn't intend to do it, so I'm not guilty of it. I intended to do it, but I abandoned my process of doing it. Are separate defenses that are mutually exclusive of each other.
He can argue that in the alternative, but
I
he's
understand
too
what you're
dumb to
saying.
say it.
I'm giving you the fact that there is no intention and there's no proof of my intention. It's only her perceived feeling. There is no proof of that intention.
And you're welcome to argue that to the jury.
Right.
But that's a defense. But then to also be allowed to argue that I abandoned, I just don't see how you're going to do that. I never intended to do it. However, I abandoned my attempt to do it.
And again, Your Honor, that's the legal argument that is available to me to bolster
It's not
my.
always available. It's available if there's evidence of it. I tell you what, I understand. Absolutely. let's start with the jury instructions, and then we'll get to that in just a moment.
Okay.
All right, go ahead and have a seat.
Thank you, Your Honor.
Uh-oh. I need my copy. Do you have a copy of the full instructions? Mine's on my desk. Thank you. My staff attorney has the instructions up, and it's just easier if she makes any changes that we discuss, because she can print them directly rather than waiting for an email that sometimes takes forever and then printing them. So we've learned a few things over the years, and it's just quicker if she makes the changes and prints them directly. I will, of course, give you all copies of the printed version so that you can verify that any of the changes that we discussed and agreed upon are in fact made. What's been handed to you was my proposed consolidation of counts 6, 7, and 8 into one instruction on neglect
I think that is him.
a child. So just so you know
Behind the guy
what
in the
it
blue
is
shirt.
and you can start looking at it, we'll insert it into the stack where it goes, and then I just want to go orderly through each one, and we'll be able to discuss it. But since it was handed to you, I want you to know what it is.
Judge, it needs to include count 9, though.
Woohoo! Law tube strikes
6,
again.
7, 8, and 9.
Boots on the ground.
Yes.
Okay.
All right, we'll make that change.
Yeah. Well, let's get.
Yeah, I'm not saying I'm giving it. We're going to talk
Yeah,
to
I
it.
was gonna say,
We're going to
let's
talk
do
about
that.
it. We may end up doing them all separate. I'm sorry, Mr. Summers. You were standing, so did you want to ask something or say something?
No, same comment.
Okay.
John's awesome.
Thank
He's a
you.
guest on my show sometimes. He's really cool.
Remember, I can pull it. What I instructed them. What's happening now, Mr. Summers, is the formal instructions on the law can either be given before the closing arguments or after the closing arguments. Traditionally, it was always given after the closing arguments. Sometimes attorneys come in and request that it be done prior to. I honestly don't care whether I read all of the substantive
He sure
instructions
is.
on the law before the closing arguments are given or after. I have no preference. But there is an initial instruction in the beginning that tells them how we're going to do it. And that's what I want to go back and look at, what I instructed them.
Warner, if you read what was provided by the state, you had stated to the jury.
I have it. Let me read it
Okay.
because this is the actual instructions that I read from. What I read was, after the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will then retire to consider your verdict. So I told them that you're going to do closing arguments, and then I'm going to give them the final instructions. Is there any requests now that after I've informed them of that, to proceed otherwise from the state,
I defer the court, Judge.
from the defendant?
I would defer to you.
All right, I'm going to do then what I told them I'm going to do in the initial instructions. Thank you all. I appreciate that. And that was the easy answer. I told them one thing, and I hate to change. I'll change as few things as I can about what I told them. Go ahead.
We gotta move these then.
So, as if they were going to be given before the closings. So the initial said that they were going to be given after, but there's something in them now, I'm being told, that indicates that they are given before.
3.1 right now says both the defense and state defense have rested their case. Please pay attention to the instructions I'm about to give you. You need to start with closing argument.
All right, so
Just give me 2 seconds.
Yes, Judge, I went off of instructions from Judge Kaiser's courtroom. I know that multiple judges like to do instructions first and then do closings, and I wasn't aware of what Your Honor's preference was, so I had just utilized what we typically do in Judge Kaiser's.
and that's absolutely not a problem. But the problem I have is
I've already fixed it.
that the instructions that were presented, you heard what I read, right?
Yes, Your Honor, I had prepared these last week. Yes.
So,
All right.
So now your first instruction will be 2.7, which is all the way in the back of that packet.
2.7. The pages stick together for me. There we go. All right, and we put that at the top. So page 60 will actually now become page 14. Mr. Summers, were you able to find that?
I can't wait to talk to
This
John
is not
about
a
it. We'll
big
get him
deal
on.
at all, but the language is slightly different depending upon whether I do the instructions before you do your closings or after you do your closings. So 2.7, closing argument. It's the introduction to closing argument. Mr. Summers, is there any objection to it?
No.
All right.
Absolutely.
So
It's
next,
really
I
cool,
would
John.
have 3.1, introduction to final instructions.
And you will not read the first sentence.
And I'm scratching out the first sentence. And we're fixing that as I speak, unless someone objects. State agree, scratch the first sentence.
Yes, Judge.
Mr. Summers, you understand and agree? I'm going to scratch the first sentence.
Yes, Your Honor.
All right. So then I'm going to read, members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions that I'm about to give you. That is, so just also so you know, after I read 2.7, you all are going to present your closing arguments. The state's going to go first, then you're going to have an opportunity, and then the state has an opportunity for a rebuttal. In fact, that's in the instruction. It says that. So then after those closing arguments have been presented is when I'm going to turn to 3.1 and say, please pay attention to the instructions I'm about to give you. The next instruction I have is 3.2, statement of the charge. Mr. Summers, have you read it and do you agree with it?
Yes, Your Honor.
Thank you. I just like to also look at it myself.
Wow, I thought they were going to take a break. I didn't think they would broadcast this. It's kind of interesting.
I've done it both ways, where it says the defendant in this case has been accused of the crimes of attempted murder in the first degree. We don't have to say how many counts. That's fine. All right. Next, I have 6.1, introduction to attempted homicide. Is this the one that?
Oh, Lord, I've done this so many times in civil cases, but it's not any more exciting in a criminal case.
Thing that has attempt.
Has the option.
Yes.
All right. So this is where, Mr. Summers, we're going to have to revisit. First off, have you looked at 6.1, introduction to attempted homicide?
Yes.
It would really be in 6.2 though. Sorry. Is where I would think you would add it.
All right.
Because that's just like the generic.
Any objection to the introduction to attempted homicide 6.1? All right. Next is 6.2, attempted murder, first degree, premeditated. And this is where in the standard instructions, there is actually an option for including abandonment. Is that correct?
Judge, the abandonment language is not in the standard instruction of 6.2. The abandonment language is under 5.1.
Okay. All right. Well, then let's wait till we get to 5.1 to discuss it. Because I don't want to deviate from standards. And if I'm going to give, as is at least right now appears to be requested, any abandonment language, I want to use the standard instruction on it.
Judge, the state did not include 5.1 because, again, it's the state's position that he's not entitled to the defense of abandonment.
Okay. So this is the idea of
Yeah.
adding 5.1.
Correct.
Yes.
Because 6.2 is the standard instruction for attempted murder, first degree, premeditated. In other situations, Your Honor, you would have the regular jury instruction, say for a sexual battery. You would have the jury instruction for sexual battery, but you would include 5.1 before the reading of the standard instruction for sexual battery. The Florida Supreme Court created the standard and jury instruction for attempted murder by itself, therefore not requiring the additional instruction of 5.1.
Mr. Summers, what? If
God, does he
anything,
need an attorney
is your
right now?
request? regarding these issues?
Your Honor, I would request that 5.1 be included with the packet. I do have a copy of that statement, abandonment of purpose. And if you would like to discuss that now.
Yeah, we are. Is that the same? Mr. Marchese in the beginning had handed me, and I don't know if it was 5.1 or if it was something that was different, but
Judge, he's providing just an excerpt from the statute. Has not provided the standard instruction for 5.1 that includes the defense of abandonment.
That's a
And not
problem.
case law that I can provide to the court for the abandonment issue.
well, go ahead and tell me. This is when we're arguing. This is where we're arguing. He's requesting. You are still requesting abandonment, even though you previously indicated to me that your legal position is you never intended to do it. Is that correct?
Yes, I'm still requesting abandonment of purpose.
Okay. So let me hear the state's response to his request, and then depending on how I decide, we'll decide where the language is going to come from, if it's going to come from anywhere.
Judge, may I approach for some case law?
Yes, and please provide Mr. Summers
Yes,
copies of
absolutely.
anything you provide to me.
I think I need to get.
God, not like he'll understand. The proper argument here is to argue what's called in the alternative. You say, assuming arguendo, you find that I intended to do this, then I abandon my purpose. It's not inconsistent, but he cannot articulate that because he doesn't know what the hell he's doing. His attorney could, but he's not
Probably
there
should
to
take the
do it.
staples out of mine in the future too. I'm sorry, Mr. Summers, you're not allowed to have staples.
Thank you.
Well, first, Judge,
I'm dying to ask John about the makeup of the jury.
Let me just make sure he has them. Mr. Summers, you have, there's 1, 2, 3, 4, 5 cases. Do you have those cases?
Yes.
All right, Ms. O'Connor, you may proceed.
first and foremost, Judge, the defendant has already stated during his previous judgments of acquittal that he did not intend to commit the premeditated act of killing Miss Mathewson. That alone, in and of itself, does not allow for an abandonment defense. As Your Honor has already pointed out, how can you abandon something you did not intend to do? Secondly, the case of, which I apologize, I did not have a copy of this one printed out for everybody, but it's Carroll v. State, 680 Southern 2nd, 1065, 3rd District Court of Appeals from 1996. And in that case, the court distinguished between voluntary abandonment,
Right.
which
I'm
is
familiar
allowed
with
by
that.
law as a defense, and involuntary abandonment. It goes on to describe involuntary abandonment when the defendant fails because of unanticipated difficulties in carrying out the criminal plan at the precise time and place intended, and then decides not to pursue the victim, or when the defendant withdraws because of a belief that the intended victim has become aware of his plans, or because he thinks that his scheme has been discovered or would be thwarted by police observed in the area of the intended crime.
That's involuntary, and that is not a defense.
That
That,
is
under the
correct.
case law, is not something that he would be able to argue.
That is correct.
However, voluntary abandonment, how does that case describe voluntary abandonment, which is a defense?
Voluntary abandonment.
For these of you who don't know, that's John right behind the victim there.
Renunciation
Looking fresh.
of any intention of committing the crime. So in this case, it would be a complete renunciation of committing the attempted murder, of attempting to kill Miss Mathewson. I provided Dixon v. State, which is 559 Southern 2nd, 354, 1st District from 1990. And in that case, Judge, the court held that once the crimes are committed, as soon as an attempt was effected, the defendant was not entitled to the abandonment defense.
Which case was that? I apologize.
Dixon v. State,
Dixon, I got it.
that case is exactly what we have here, Judge. The defendant committed and attempted to commit by putting a pillow over Miss Matthewson's face, then getting on top of her, putting more pressure on that pillow to the point where she actually loses consciousness. His own self-serving statements and his post-Miranda interview with Sergeant Remia is not sufficient to allow him to have the abandonment defense, because he has already, and even in his own statement, admitted that he effectuated the crime. As far as the commission of the strangling for count 2 with the rope, the state's position is that we have testimony that his actions were thwarted because he believed he saw an undercover police vehicle. That is involuntary abandonment. Therefore, he is not entitled to the affirmative abandonment defense for either count 1 or count 2. The courts have even addressed this issue with felony murder cases. And the courts have cited and stated, even if the actual or the defendant was not included or took part in any way of the murder, if that defendant took part in the underlying felony, they were not entitled to the abandonment defense. That is cited in or discussed in Smith v. State, which I provided 424 Southern 2nd, 726, Supreme Court of Florida, 1983, Kane v. State, 698 Southern 2nd, 1254, a second district court from second district court of appeals case from 1997, as well as Miller v. State, 503 Southern 2nd, 929, a third district court of appeals case from 1987. And in that case, Judge, I'll note that the court considered the defendant's self-serving statements to the police, where he relied upon his innocence. And we have that situation here, Judge, where the defendant is relying upon his statement to Sergeant Remia, where he is saying that he didn't intend to kill her, and therefore he should be entitled to the abandonment defense. So for all those reasons, Judge, it's the state's position that the defendant is not entitled to the affirmative defense of abandonment that would be included in the standard instruction of 5.1.
All right, thank you, Ms. O'Connor. Mr. Summers' response.
Yes, Your Honor. According to Longbow v. State, which is the case that you had mentioned earlier.
Curtain
Yeah, I
house.
think I cited 2 cases to take a look at on the abandonment defense.
So we decided not to testify on his own behalf. I'm very disappointed.
It states that a defendant is entitled to have the jury
Yeah, it's a
instructed on
bummer.
the rules of law.
And so what is he trying to argue? I didn't
Applicable
intend to
the
do it, and
defense
also I gave
if
up my
there is
intended
any
attempt.
evidence to support such instruction.
Absolutely.
No
And
matter how
also, did you
flimsy
see
that evidence
John's in the
might be.
courtroom?
I agree. Well aware
Yes,
of
I
that
did.
proposition of law.
That's
And then it says, in
awesome.
determining
Law
whether
tube
to
strikes
give
again.
a requested instruction, the trial court should
He's
consider
now motivating me
evidence
to go to
presented
Idaho so I can be in the
without
courtroom for the Daybell trial for at least
the
one
latter
day.
if a task
Oh, that'd be awesome.
And so that puts it to the jury to decide if there was an abandonment of purpose. Additionally, Your Honor, in
Rob also says hi. He's sitting next to me.
Oh, that's cool.
according to the instructions on
Hey,
crimes,
Rob.
I'm quoting
The Law 2
from
Bachelor
the,
Pad.
Criminal Laws and Rules, 2012, Jury Instruction in Criminal Cases. I'm at
What was the rule? I'm sorry.
Defense Rule, Section 777.04.
Oh, fancy. We got
5A.
lighting and everything. Look at
Statute.
that.
It says, it is not an attempt to commit crime charge.
All
if the
right, I'm going to
defendant
refresh my
abandoned
coffee real
his or
quick.
her attempt to commit the offense or otherwise prevented its commission under circumstances indicating
Actually
a
makes a pretty big
complete
difference.
involuntary renunciation of his or her criminal purpose. And Your Honor, again, I have not testified to trying to kill anyone. The evidence only shows the statement by the
Oh,
victim,
is he killing anyone?
the involuntary statement by myself, both show that a pillow was put over her. But it doesn't say to kill her. In my defense, it doesn't say to kill her. It could have been to just keep her quiet. It could have been for something we were doing in the bedroom. But the intent to kill somebody has to be
Also, he's wearing a white
easily
collar with a
recognizable.
colored shirt, which is not a look I like.
Just because of a look on my face doesn't mean that there's something in my heart that says that's what I intended to do. And there's no statement by me saying I intended to do that. It's only an impression. And it's so the circumstances don't meet the threshold, don't rise to this level of attempting to kill someone. And in that manner, if I didn't intend to do it in the first
It's only an
place,
impression.
I
The only
abandoned
impression from
any
holding the pillow over my
effort
face.
to actually commit that crime.
See, what I hear you saying is there's absolutely no evidence
I was definitely
of your
impressed.
intent.
Yes.
Well, the very first element of 6.2, number 1 is it says to prove the crime of attempted first-degree murder, the state
I was
must
also trying to make a pun
prove
with passing the
the
pillow.
following
there.
3 elements beyond a reasonable doubt.
Yeah.
Number 1 is that Trevor Stephen Summers did some act intended to cause the death of Elisa Summers. So that's your defense. That they haven't proven that you did anything to intend, that you had no intent, that they can't prove intent. I don't understand why you want to argue abandonment when you're
Even more
saying
lighting.
that in order to support that, there's no evidence that you intended. And that's the exact argument or attack on the elements of their claim. They have to prove you intended.
I understand. And maybe the best way I could explain my understanding of it is this: a moment in time where a decision is made
My understanding of the law.
from messing around with a pillow to intending to kill somebody. And maybe it was Mrs. Mathewson's impression that at that moment in time, that split second, she thought she was going to be killed. At that moment in time, I thought this could go further, but I didn't. And so I guess I'm pointing to that moment in time when a decision could have been made to be much more severe. And at that moment in time, that decision to, or that potential decision to go more severe was abandoned.
Anything else?
No, Your Honor, those are the ways that I've been able to consult with Mr. Marchese about. That's the best I can explain. I understand it. And I do believe it has some merit.
I thank you, and I appreciate your argument and your position. I will say this. I only make rulings that I believe are not going to be reversed by the appellate court. So I believe that I'm right on my ruling. But I caution the state that if the appellate court thinks that I'm wrong, probably one of the most common reasons I have seen retrials is the court's denial of a requested defense instruction on the law. And the appellate court says you should have given it. I'm not giving it. I'm ruling in your favor because I think you're right. But most of your argument is that it's a crazy defense and there's no way, which are all things that if I gave the instruction, you could argue to the jury, even though there's just absolutely no abandonment. And that would eliminate any appellate issue of the appellate courts then saying.
So advising the
should have given the instruction. I'm
prosecution
not
that
giving
maybe
the
they don't want
instruction.
what they're asking for.
Unless
Yeah. And I think
you
he's right.
concede to me giving the instruction because I think I'm right. I think you're right. But the important part of that sentence is I believe that you are right. And I believe that he's not entitled to the instruction. But there's no question if you prevail and he is convicted that that's going to be one of the top appellate issues. And that's the only reason that I say that.
I agree.
So, Ms. O'Connor, it is my intention at this time not to give 5.1 attempt abandonment unless you change your position.
Judge, it's the state's position that the defense's argument is that the state has failed to prove beyond reasonable doubt element 1, that he intended to cause the death of Miss Mathewson or Miss Summers during the dates of these offenses. And for that reason alone, he should not be entitled to the abandonment defense.
Okay, I'm not going to give the abandonment defense. I think there's also the other issue that's going around there about I just don't think that you can argue lack of intent and also abandoning something that he never intended to do. Just
It's
so
a
the
tough
record is
position to
absolutely
hold.
clear on the
Mutually
reasons,
inconsistent
both reasons
defenses.
that I am denying his
Especially before a
request
jury. Good
to
luck.
give the instruction. So with all due respect, Mr. Summers, I'm denying the request to give an abandonment instruction.
I understand. Thank you, Your Honor.
You're welcome.
So we're just on 6.
6.2 as is, there won't be any instruction given prior to or any addition to 6.2 other than, and you're not waiving your objection, it is perfected for the record, or your request and my denial. Other than that, any issues with 6.2?
No, Your Honor, I do maintain my objection.
Absolutely. It is preserved for the record.
Nice
On
for him
appeal.
to mention that.
3.3 is what I have next. Aggravation of attempted first-degree murder by carrying, displaying, using, threatening to use, or attempt to use a weapon. Any disagreement, Mr. Summers? Any suggestions or issues?
Yes, Your Honor. I have just a question of the definition. Is it both 1 and 2 or 1 or 2?
I'm sorry. Where? Oh, as to counts 1 and 2. Yes, both.
Okay, and the weapon is defined as both, is number 1, an object, and so forth, or number 2, an object, or so forth.
That is correct.
Thank you.
You're welcome. Any other issues, questions regarding 3.3a?
No.
All right. Next, I would give 9.1 kidnapping, which is as to count 3.
Well, that all seems to be in order.
Where are you going, John?
Issues regarding 9.1 kidnapping?
No, Your Honor.
All right. And you do see, I notice now, because element 3 says that Trevor Stephen Summers acted with intent to commit or facilitate the commission of grand theft motor vehicle. Right under that, it says, see the definition for grand theft motor vehicle, which is in count 10, which we will ultimately get to. So it's actually instructing them to go forward to count 10 to see the elements of grand theft motor vehicle. You understand that?
Yes.
And have a problem with that? Okay. Next is 11.4 sexual battery. 4 elements. And we have to eliminate at least the italicized give if requested.
The victim's right there in the middle left, just close to the guy in the blue shirt.
Is the state requesting that?
Yes, Judge, we are.
So, Mr. Summers, do you have any comment on that? What they're requesting, that line after give if requested?
Yeah, I would ask that be removed.
Removed?
Yes.
Do you intend to argue that? Is that, I mean, what it says is that her lack of chastity is not a defense to the crime. You intend to argue that the defense is her lack of chastity?
Honestly, Your Honor, I don't see the relevance, but that's just my.
It's part of the standard, and the instruction says give if requested. The state is requesting it, so I am going to give it. But we're going to eliminate that language that says give if requested.
Yes, Your Honor.
All right.
Thank you.
You're welcome. Next, I have 16 points.
This is the one where the proposed.
Lack of chastity was exactly what he was just arguing.
Okay, so I don't have it on mine. This is
It's
the
that.
one we handed out. Yeah, thank you. Where did I put that?
We'll call that the 304.
Here it is.
And I would add, I've already.
I call that a
added
rape
count
shield
9.
law problem.
Okay. All right. So what I am proposing here, if you look at 16.6 neglect of child on page, in this stack is 23, then you would have on page 24 also 16.6 neglect of child. Then after that, another neglect of child. Then after that, another neglect of child. Then after, so that's the total. The only difference in all of those instructions is the initials of the child. So what I've proposed and what was handed out prior to court beginning this morning is 116.6 neglect of child, but in paragraph 1, including all of the different initials. So it would read as follows, just for the record. And we'll put a copy of it in the record and we'll see if anybody has any objection. Trevor, number 1, would read, Trevor Stephen Summers willfully or by culpable negligence failed or omitted to provide A.S. count 6, L.S. count 7, and or B.S. count
It'll be BS count 8 and or GS count 9.
Okay. With the care, supervision, and services necessary to maintain AS count 6, LS count 7, BS count 8,
And or GS.
Yeah,
and
that's
or
cute.
GS count 9, physical or mental health. And then in
I assume
2,
those are minors'
it says
initials.
Trevor Stephen Summers was a caregiver for AS, LS, BS, and it'll say and or GS. Same with count 3. So same theme here. It'll be AS count 6, LS count 7, BS count 8, and or GS count 9 were under the age of 18
I agree,
years.
BS on count 8. Your Honor.
Does everyone
Couldn't agree more.
understand that consolidation into one instruction?
Yes.
Thank you, Mr. Summers. State.
Yes, Judge, I just think that, and I don't know if maybe I know there is a instruction that you need to consider each element separately and distinctly from each and in every other count. I don't know if we need to maybe add something that they are going to have to make the determination as to each element, as to each victim. It's on the verdict form and clear, but because we're putting it together, I don't know if we need to add any language.
We'll ask John when we get to talk to him.
I tell you what, we're going to spend more time talking about it than me reading. It's a half a page instruction 4 times. So I'll just read it 4 times. So forget what I handed out to consolidate. 16.6 count 6 as to
Just read it 4
AS.
times?
Any objections,
works too.
Mr. Summers?
No, Your Honor.
Next is
I get it.
16.6 neglect of child count 7 as to LS. Any objection?
No.
Next is 16.6 neglect of child count 8 as to GS. Any objection?
Yes.
Cowboy
Needs to be
Fez.
corrected
To BS.
to BS.
I don't know if such a thing exists, but I'm intrigued.
Judge, would the court consider?
Wait, state, do you agree that it should be corrected to the correct initials of the child,
As to count 8, yes,
which is instead of GS, BS?
correct.
All right, I just want to make one change at a time. If we all agree, my staff attorney can make that change. So GS is being changed to BS. Now, Ms. Johnson, you had something else.
Once
Chat
you read
from
the
the
entire
inside.
instruction as to count 6, I don't know if the court would want to say, the further definitions given, I read to you previously.
Okay.
So they can still be there on the form, but you don't have to reread them. Neglect of a child, the definition for caregiver, and the definition for culpable negligence when you read 7, 8, and 9.
I like the judge. I think he's pretty darn good.
If you're not going to consolidate them into one standard, I would just stick with the standard.
Yeah, let's just stick with the standard and abundance of caution. I appreciate that, but if I'm not going to consolidate them into one, I don't want to do something
That's away from the standard.
to deviate from the standard. So go back to the one where we made the changes. That was count 8. Now says BS. Other than that, Mr. Summers, any questions, issues, objections?
No.
Next, I have count 9.
Nope,
Which
he
is
decided
also
not to.
16.6 neglect of child, and this one is now
Disappointing.
GS. Any objections?
No, Your Honor.
All right.
But he's still
Next,
going to
I
have to give his
have
closing statement, in which he can say all kinds of
14.1
crazy
grand
things.
theft motor vehicle, which is count 10.
Did you catch any of
It
his
is
cross examinations, pro
One
se?
page, full page
A little
long.
bit, yeah.
Mr.
Yeah.
Summers,
Did a little
any
bit with
issues,
fun
objections,
Lita.
questions?
Fun stuff.
No questions, no objections.
Thank you. Next, I have, well, you know what? Just to be for the record is clear. You said no questions. Any objections?
I said no questions, no objections.
Oh, I'm sorry. I didn't hear the second part. I appreciate that. Thank
He
you.
might still be
Next, I
standby
have
counsel.
8.18, which is as to count 11, violation of an injunction for protection against domestic violence. Mr. Summers?
No issues.
All right. Next, I have 3.4, when there are lesser included crimes or attempts, and specifically the lesser included crimes that are indicated in this instruction for attempted first degree murder are attempted second degree murder, attempted manslaughter, attempted aggravated battery, and attempted battery. There are the lesser crimes indicated for the definition of kidnapping is false imprisonment. The lesser crime indicated in the definition of sexual battery is battery. And finally, the lesser crime indicated in the definition of child neglect is culpable negligence. Any questions, issues, or objections to 3.4?
Not for me, Your Honor.
All right. I accept that there's none from the state since it was what the state proposed. So state, that's why I'm not asking you to chime in unless you would like to.
Yes, Your Honor.
Next, I have 16.1, introduction to attempted 6.1, introduction to attempted homicide. It is one page, full page, and then goes over to 2 lines and a portion on the next page. Mr. Summers?
Just a question if
Yes.
this is required to be in here again? It's already at the beginning of the packet.
State, why is it in here twice?
It says in the instruction that it needed to be offered again, but if you want to say, please refer to 6.1 for the introduction to attempted homicide before you read it's on underneath the list of the lessers. Down at the underneath the box, it says you need to reread the introduction to attempted homicide. But if you want to just put a line, see instruction 6.1 prior to attempted first degree murder.
That's the way I've seen it before. I
That's
mean,
fine.
that's pretty common.
I was just trying to have more. It's easier to take out than to add. Yeah.
I don't have an issue with that. And that's why we have this charging conference and can discuss. And that's, can you make that change?
Yeah, but so you want to, is this like under 6.4 or you just want one page that says, please refer to 6.1?
I think
No.
it needs to go before 6.4. It needs to be above it somehow.
Okay. I can leave.
Looks like he was basically a grifter.
And say, please refer to,
That's what I've done before.
Some of our best friends are
Yeah,
grifters.
that sounds familiar. So I think that I've seen. So, Mr. Summers, you actually suggested or asked why it's in here twice. So what we're doing now is proposing to take it out the second time and simply
Fraud.
put
You did
the
fraud for a living?
put
That's
to
cute.
see the other time.
okay, so you're going to have a page that just has 6.1 introduction to attempted homicide. Underneath that, it's going to say, please refer to instruction 6.1 as previously given.
Yes.
Good? Okay.
Okay.
Yeah, and you're all right with that?
Yes.
And state's all right with that?
Yes.
All right. So I'm taking that 6.1 out. And
I suppose because
put
we're
it
talking
in
attempted
the,
murder, we're talking like a life sentence possibility.
garbage. I'm sorry.
Yeah.
6.4.
I would think so, but I don't know.
Murder, and this is the lesser as to counts 1 and 2. It is, I believe.
I don't know if you want to
2
discuss
pages.
this
It
now,
goes
but
on
I'm
to
not
the
sure about the
second
attempted
page.
murder.
What
charge. I
I'd
think
like
the other
to,
ones
if
are
we
solid.
can, I don't like the spacing.
no, I
have.
agree.
Reformat it.
But I didn't see a lot of the
So there may
trials,
be
so I
some
don't know.
reformatting. If you see the one you have,
Yeah, exactly.
in section E, it ends with Elisa, and then on the next page, all it has is Summers.
But yes,
so
that's
we're
tough
just
to
gonna
establish.
Reformat that. But as to the content, is there any issues or objections or questions, Mr. Summers?
I do have a question or an objection, both. I was not aware that there would be these types of other options for the jury, so I'm not very prepared to argue or include these in any kind of closing argument. I don't know if that's a valid objection, but I just want to state for the record that I'm a little bit surprised by these lesser offenses,
Mhm.
and I
Oh,
believe
you're
that it
surprised by lesser
diminishes
included. Okay.
my ability to.
I understand. I hear you. But I'm going to say that this is perhaps one of the disadvantages of representing yourself as you've chosen. The law includes category 1 lesser includeds that are required to be given to the jury. These are actually category 1, and the jury must be instructed on them and have the option of finding you guilty of something lesser than the crime that is charged. And then these are all of the category 1 lesser included instructions. So
If we want to go for a lesser included of like attempted murder, like some sort of aggravated assault or something, I'll give them that.
Category ones are
That'd be fine.
required. Any issue, any difference, or
Yeah, I think that's the
comment from
interesting
state?
charge. Whether
And
or
let
not
me just
he
verify.
gets convicted
I
on that.
verified that. Well, all of the ones that you've included are in fact Category 1 lessers. Is that correct?
Only category 1, Judge.
Okay. Now, all right. So I just want to verify. The law says Category 1s must be instructed, even if the defense says I don't want them instructed. All right. So other than that question, sir, any objection regarding the content of 6.4 attempted second-degree murder?
No, Your Honor.
All right, thank you. Next, I have 3.3A, aggravation of attempted second-degree murder by carrying, displaying, using, threatening to use, or attempting to use a weapon. And this is as to, I apologize, this is as to counts 1 and 2, Mr. Summers.
Yes, I understand it, Your Honor, and
You know, I didn't think of that, but he kind of does sound like Hogue.
double checking with the first. So is this a duplicate of page 20?
I don't.
Sure, but it needs to be clear that the existence of A applies to even the lesser, not 1 or 2.
It's the same language. But this is where they're being informed that this aggravation also applies to the lesser of second degree, second degree.
Oh yeah, and apparently by
As
noon
I
today,
sit
I don't
here,
know if it's
I
already
don't
happened.
recall any
Some version of
consolidation. I
the
think on this one
affidavit for the Trump case
is
is getting released.
perhaps
I'm looking forward to covering
redundant,
that.
but I don't recall ever consolidating.
Typical Friday dump.
It's going to get pretty confusing. I'm concerned if we do anything else. Trust me, I'm no happier than anyone having to read all this stuff twice. They're all 60 pages. But other than state, did you have any comment?
Not as to that, Judge. We do need to revisit 3.4 whenever we're done addressing this issue.
Which was the previous one?
3.4 is the lesser crimes included. It needs to say the lesser crime included is attempted second-degree murder.
I don't know
With
what the
a weapon?
sentencing
I'm
possibilities
sorry,
are here.
Judge,
I
that's
just don't.
incorrect. You just gave the solution.
Okay, and let me just
I think
give
they'd
me
be
a moment and
significant.
so we can all turn back to it.
Yeah,
Page 30,
Page.
maybe.
What page are we?
I assume
referring
the
to?
attempted murder charge is life.
Did you see when
This is why we do these charging conferences.
he
so we
discussed
can
bringing a
determine
machete to
any
the meeting
issues before I'm reading. It's actually on page 29.
on
Mr.
his
Summers.
cross?
It's the 3.4 lesser included
Well
crimes
done.
and attempts.
What did
And
he
I
say?
apologize, Ms. Johnson. Tell me specifically what the issue
He
is.
said I tied her up
So,
and had a
Judge, I
machete.
guess we're questioning the charge for counts
Having the
1 and
machete
2 is
does help
attempted
with the
murder in
attempted
the
murder
first degree
charge.
with a weapon. So do we need to list
It nudges you in that
a
direction, doesn't it?
lesser is attempted first degree murder, period, with no weapon? But I had the special finding on the verdict form where they would make a finding as to he's guilty of attempted degree murder, and then they make the special finding. But I don't know if we need to list that attempted murder in the first degree without a weapon is considered a
What's
lesser.
standard? What have you done before? I mean, what do we usually do?
Well,
This guy's better than
in
the top
another
set. I'll give him
case,
some points.
Miss O'Connor did
Agreed.
the attempted murder in the first degree without a weapon is, she didn't put without a weapon.
He's
because
basically a
attempted
typical
first-degree
pro
murder
se,
was considered
just
a lesser.
clueless.
It is a lesser.
I've seen worse.
Well, I'm concerned also that the lesser crimes indicated in the definition of attempted first degree murder should then say attempted first degree murder with a weapon, because it,
Hope this shit
it
gets
wouldn't
picked up
sound
for next
right
season.
if
You and me
then
both.
if that didn't include weapon and the second one it also didn't include weapon. There has to be some distinction.
Correct. So we would need to fix that.
So that would add an additional, and let me, I mean, there's a chart. I don't have it in front of me, but
So it doesn't have for attempted first degree murder, it doesn't verify,
do you have any
there's
problem with
no,
going
there's
along
not
with
one
the
for
name
with
or
a
the,
weapon and
6 points?
without. It's just attempted first degree murder, and then you have the aggravation for with
I'll
the
schedule
weapon. So
that.
there's not a chart for attempted first degree murder with a weapon. It's just attempted first degree murder.
so we can't say it's a category 1 lesser if it's not on the chart as a category 1.
It's, yeah, right. It's not a category 1 lesser.
Yeah, I mean, it makes
the weapon
sense.
is a special finding. It's an aggravator. So that's
Right.
why I did not include it. But
Right.
I know you've had other cases where you have included it.
Well, what's your request? Your request is not to include it because that was the proposed instruction. Mr. Summers, do you want, this is one I think that it's appropriate to allow Mr. Summers to weigh in on if it's not a category 1, because he didn't appear to want any of the lessers, and I told him they're category 1s and they have to be given. So if this isn't a category 1, I think it should probably ultimately be left up to him. And the state didn't originally request it, so I'm assuming the state didn't want it. Mr. Summers, do you understand what we're discussing?
Yes, whether or not to include the lesser with
Of
the,
simple attempted first degree, simple, that is just a word doesn't even go with that. But of attempted first degree murder after attempted first degree murder with a weapon.
right. I believe it should not be there.
Okay. Do we need, though, anything about the weapon? I think I agree with Ms. Johnson that that's just an additional finding. The charge, should it say, I want it to track, though, count 1 and 2. I apologize. Jury instructions, sometimes they're very tedious and no offense to the Supreme Court, but complicated. But that's why I take time and want to make sure that they're absolutely correct. So does the state have a position on the lesser crime indicated in the definition of attempted first degree murder or should it say definition of attempted first degree murder with a weapon? It's not in.
Yeah, she just did it as the instruction on aggravation, right there.
And a finding,
As
yeah.
a finding. So I think it's fine that
I think
way.
it's fine this way too. I mean, this is the opportunity.
Can I just have a moment, Judge?
Yes.
Oh Lord. Earlier he said, "Oh yeah, we'll let the jury go for 45 minutes." I'm like, "It'll take longer than that." I know it will.
We're going to finish today. I'll put bets down.
But if they do this, I mean, all we have is closing arguments, and then I think they get it out. I think we get a verdict today at this point, since he didn't
Yeah.
testify.
I can't wait for closing
Probably this
argument.
afternoon.
Tell Mike I'm setting up the stream for Friday night.
But I'm with you. I think
Yeah.
all the charges except attempt murder, he basically confessed at some point during
Yeah.
the trial.
You got kidnapping. You got the sexual assault. The only one that's challenging is the attempted murder.
Yeah, and somebody
Rob
was asking
says
him,
that he's
you know
setting
what?
up for a streaming tonight. We're doing Friday Night Frenzy, so that'll be exciting.
Oh, really?
Yeah.
Well, yeah, let's not talk about the last time that happened. All right, and to make up for it, everybody go over and like and subscribe Kurt's channel. Give him some love. I gave him a hard time last Friday night. There might have been cocktails involved. I'm just saying. Although we did have fun. It got rowdy.
Yeah, let's move past that. Anyways, back to the trial hand.
And we're walking.
Is for the moment, Judge, maybe readdress it at the end.
Okay. Yes, absolutely. Leave it as proposed and as requested by the defense. So that's right. I'm at 3.4. Did we have something else?
Really, we left off on 3.3A, the second reading of 3.3A, which is after that.
Oh, so we were actually one part. No, it's not after.
Well, but it should be. Yeah, you're out of sorts.
So what page should we be on? I'm sorry. When I flipped back to that Lesser's,
Because this is where we started. Are we going to do a second reading of this?
I think we agreed that we were going to do a second
Yes.
reading of 3.3A. That was my ruling, and I'm going to stick to it. So moving on from 3.3A is now 6.6, attempted manslaughter by act. Mr. Summers, any issues, objections? And this does have one of those italicized and in parentheses, the explanation of justifiable attempted homicide and excusable attempted homicide are in instruction 6.1, introduction to attempted homicide, which was previously given. You see that
Yes, Your Honor.
note on there? So that we're not doing it twice.
Understood.
So do you want me to italicize that, or do you want me to cut that?
No, that needs to stay.
Well, you already say, as I had previously instructed you.
Oh, as I previously instructed you, yeah. Mr. Summers, do you have any problem with just eliminating what's in the parentheses because that's preceded by as I have previously instructed you?
No problem.
State, why was the italicized and in parentheses language here? Were you requesting it?
It does create
Judge,
questions,
it's
doesn't it?
included. The italicized part is on the standard instruction, so I'm not sure if this is a situation where because it's italicized, taking it out versus the Supreme Court putting it in there to then allow Your Honor to simply read that saying this is where refer to 6.1 for that definition. I think
My recollection, I mean, I could be wrong, trust me, I'm not always right, but is that it ends in the past,
you're always
that
right,
it
you're the
ended
judge.
there, as I have previously instructed you, period. This language I haven't seen before, but I'm not questioning you on that it's included in the standard. Do you have the standards up?
Hold on.
Yeah, let me take a look at the standard to see if it has.
Typically, when it's in italics, you don't read it.
I think that's just in the standard letting you know.
right, and that's
So are you requesting?
refers back to the instruction of 6.1. So it's fine if you want to take out what's italicized in the parentheses.
Well, but I guess what I'm trying to figure out is why it's in the proposed instruction. Were you requesting that I read what's in the parentheses or not requesting it?
Yep,
Judge,
this is
I
what
left
happens
it in there
every
because
time.
I wanted the court to know that that was in the standard instruction. So we just need to make sure we address it. However you want to address it is fine, but I wanted to make sure that we didn't forget to
All right,
address
well,
it.
the proposal is that we take it out, and I think that Mr. Summers is in agreement, correct? All right, so I'm taking it out. Next, I have 3.3A, aggravation of attempted manslaughter by act by carrying, displaying, using, threatening to use, or attempting to use weapon. This is a lesser as to counts 1 and 2.
Pass that along to Rob, Kurt.
Issues, questions, objections, Mr. Summers.
None for me, Your Honor.
Let Rob know he hasn't scheduled
Next,
Friday Night Friday yet.
I have 5.1, attempt to commit aggravated battery, lesser as to count 1. And why isn't it as to count 2, State?
Also, they have that pretty much twice, so I don't think a preference between the way they have that.
Also, taking a look at the first 2 sentences, it's kind of redundant. Is there a way that we can change that or address that? See how it's, I can't imagine that both of those are required.
That might be a typo, Judge. We'd have to I need to pull up the original instruction.
I've lived through many
So
jury
attempted
instruction
aggravated battery
conferences.
is a category 1 lesser.
Never thought I would stream one. Never in my wildest dreams.
I mean, it says the same
Just
thing
can't
in
get
those
enough
two
of them.
sentences. They're slightly, ever so slightly different. I don't care which one we use.
We need the top one, Judge, not the second one.
All right, Mr. Summers, do you see how those first two proposed sentences are practically identical, but it's just repeated twice?
I do.
Do you have any problem with removing the second one?
No.
All right,
And Judge, for the record, for 5.1, the standard instruction for attempt to commit crime, that first paragraph, it says to use when attempt is charged or is a lesser included offense. So that is the more appropriate one to read.
the top one.
Yes.
Okay, not a problem. I accept that. But why is this only a lesser as to count 1 and not a lesser as to count 2 was the only question I had.
It needs to be as to both, Judge.
Man, they seem to be doing fine to me.
All right, we'll make those changes. Mr. Summers, do you disagree?
No.
Okay, we have the same thing in the second paragraph. The crime of aggravated battery is defined as, and then to prove the crime of aggravated battery, the state must prove the following 2 elements. One of those has to come out. Which is in the standard? Or which one is pursuant to the standards more appropriate, Ms. O'Connor?
I'm sorry, Judge, where are you at?
Just under element 2, it says the crime of aggravated battery is defined as, colon, then under that it says to prove the crime of aggravated battery, the state must prove the following 2 elements beyond a reasonable doubt. The first element is a definition of battery. I think the second one is more appropriate. I think that first one that's just left hanging there is, I don't know why it's there.
Because that was probably the beginning part of the actual aggravated battery instruction.
So is that a typo?
So in the standard for 5.1, it says the crime of, and then you put the crime attempted is defined as, and then you insert the elements of the crime attempted. So
Does it make sense to have both?
no.
The jury
I
should
don't-
be out.
I
They
think
should
think
be
it
out
does.
right now.
either works. The second is a little longer and has the explanation of the first element of is the definition of battery. I will tell you that my preference is for that one. Any objection from the state?
We defer to the court, Judge.
Any objection, Mr. Summers?
No, Your Honor, whatever you.
I'm scratching the crime of aggravated battery is defined as, colon, that's coming out.
The jury
Anything
instructions
else
are
that
always confusing to a jury.
Spills
They really
over
are.
onto a second page. So make sure that we're all on the same page as to reviewing 5.1 attempt to commit aggravated battery. Any other issues, questions, objections?
I believe it should say the first element is a definition
Oh.
of battery, and is
You
defined
definitely are
as-
going to cite that on the appeal.
That's not the way the standard language is. I'm going to follow the standard language. You may have an issue with the Supreme Court and think that it could be done better. I sometimes might say the same thing, but I'm not going to say that. But I'm going to follow the standard, and that is standard.
Okay.
Any
Yeah,
other
Kurt
questions,
and I just
issues,
did.
or,
We had a big row on the jury
objections?
instructions in the Daybell
As
case.
to 5.1.
This is typical
All right,
stuff.
thank you. Next, I have 5.1 attempt to commit battery.
Again, this should be lesser as to counts 1 and 2.
And it says that it's a lesser as to count 2.
Oh, thank you.
Is there any reason why it's not a lesser or should not be a lesser as to counts 1?
Judge, I think the instruction we just went over needs to say lesser is to count 1 and 2.
We made that change.
So this can be taken
So
out.
now we're at 5.1, attempt to commit battery. That's in a different lesser. And it only says count 2, but it should say count 1 and 2. The other one said only 1 and should have said 1 and 2. This one says only 2, but should be, I think, 1 and 2. I'll give you a moment.
Judge, there was a reason behind this.
Okay.
But I cannot remember at the moment. It was a conversation that I had with Ms. Marchese, but I
I'll
can't
give you a
explain it right
moment
now.
if you need a moment.
No, Judge, I think that the way we previously discussed it is appropriate. It should be under 1 and 2. It should need to say lesser as to 1 and 2.
Okay, Mr. Summers, any disagreement, questions, or objections?
No, I understand. I agree. One
All
and
right.
two.
No. Sorry, you got this again.
In the body of it, it says the crime of battery is defined as : then under that it says to prove the crime of battery. I'm striking the crime of battery is defined as : Any objection, comments, or questions from either side?
No.
I agree with that. And the same thing for the top of the page, to prove and then in order to prove.
He's right.
You get
Which one did we do?
Top one.
The top one? Thank you, Mr. Summers. I'm scratching in order to prove that the defendant attempted to commit, and I'm simply leaving to prove the crime of attempted battery. The state must prove the following 2 elements, and then it'll go right into the 2 elements instead of the sentence that is on the paper that you see. Any objection, state?
No, Judge.
Next, I have 9.2, false imprisonment, lesser as to count 3. Mr. Summers? Objections, comments,
Nothing from me.
questions? Thank you.
The only thing I noticed, and I'm not sure if it's on yours, is that
Mine is what you gave me, so
The victim's name needs to, for the
Kurt's got
definition of
videos on it.
secretly, it needs to say Elisa Summers where it says victim.
okay. Mr. Summers, any objection to changing what is now in parentheses and says victim to the actual name of the alleged victim, Elisa Summers?
No, I understand.
That change is being made as we speak. Next, I have 8.3 battery, lesser as to counts 4 and 5.
And I just put the victim's first name. We need to add Summers.
I see Summers in.
Oh, no.
It's in there twice.
Yeah.
Oh, okay. It's in there 3 times. It's twice it has Summers, but 1 time it has Elisa. Mr. Summers, do you see that? It's actually in the element 1 towards the end of that first sentence where it says touched or struck. It just says Elisa. We're going to add Summers as it is the first time and the last time that her name is mentioned.
I understand.
I
Any other
invited Natalie.
issues, questions, or objections related to 8.3?
Just saying.
All right. And you made that change. You added Summers?
Uh-huh.
Next, I have 8.9, culpable negligence, lesser as to count 6.
Okay, this will be 6, 7, 8, and 9. We only need to do this once. I just need to add all the additional. Oh, we didn't make that change. I'm
No,
sorry.
yeah,
I'm sorry.
no.
But you don't want to make the change on this one? Okay.
No. We're going to leave it as is. Mr. Summers, any questions, objections, comments? It's going to repeat now 3 times,
I understand. No problem.
4 times. All right. Okay. Next, I have 8.9, culpable negligence, lesser as to count 7. Same language, except that the first one was AS, the second one is LS. Anything, Mr. Summers?
No, Your Honor.
Next one is 8.9, lesser as to count 8, and the initials are BS, which is correct, right? No?
Yes.
Yes. Next, I have count, and just for the record, Mr. Summers, no objections?
No.
Next, I
There's
thank you.
the spacing on lesser to count 8 just needs to be fixed there for 1 and 2.
I'm good. I've got it.
Okay.
You're fixing that?
I got
Alright.
the whole thing needs.
We did say we were reformatting, and you will see that. We will print it out so that you can see it. But what I'm most concerned about is the content, and then we will reformat, send it to you, and if you have any objections or issues, I will ask you once you've been given the final copy after reformatting if it creates any issues that you wish to raise. Next, I have 8.9, culpable negligence as to count 9, and the initials are GS is the only difference in this one.
Yes, other than just the spacing on number 2 as well. That's it.
All right, we're fixing that. Next, I have 3.7, plea of not guilty, reasonable doubt, and burden of proof. Mr. Summers, do you have an opportunity to review that?
Yes, I have.
Any questions, objections related to that?
No, Your Honor.
All right. Next, I have 3.9, weighing the evidence. Now, this one is going to require us perhaps to take a look. There's 9 individual enumerated paragraphs, and they don't usually always come in. They're not always appropriate. So let's take a look and see if any of 1 through 9 should be eliminated.
I think it's only starting at 6, Judge. 1 through 5 are standard.
Right.
So the state's position is 6, 7, and 9 are not appropriate.
Not appropriate?
6, 7, and 9.
All right, Mr. Summers, I need you to look at 6, 7, and 9 and either agree, disagree. The proposal is to take out 6, 7, and 9.
I would leave 7, Your Honor.
And any pressure or threat use of the witness's testimony, I'll leave it. I'm going to leave 7.
Okay, hold on. So I'm cutting 6.
Do you agree, Mr. Summers, to eliminate 6?
Yes.
Okay.
Not 7. We're going to keep 7.
I'm sorry, Your Honor. I believe preferred treatment would also be important. I would leave 6.
Has the witness been offered or received
Good idea, Evan.
in order to get the witness to testify? What, if any, evidence do you propose?
What if any?
Suggests
It's
keeping
going to be
that
a
in?
hot minute before that phrase stops
I
burning
believe
in my
just
mind.
the number of media interviews, press releases, all these things that witnesses have done in this case.
I don't know that there's any
I'm a judge
evidence
that
of
didn't
that
have a
before
curse
the
jar on
jury.
my bench.
You can only argue evidence that was admitted during the trial.
Okay.
All right, so 6 comes out. You want 7.
Yes. Well, Your Honor, back to 6. Is there any preferential treatment based on the cameras and the media coverage of this trial in this courtroom?
I mean, I don't know. I'm not answering questions. Is that your position now, that you think that's appropriate, that you're going to make some argument as to that effect?
I believe it has some merit.
So you intend to argue that the credibility of some witnesses were affected by the presence of media, even after the instruction that I gave specifically to the jury to disregard and to not let that affect them in any way?
Oh, here we go.
I won't be arguing that at closing. No.
All right, then so we're going to eliminate 6. 7, though, state has suggested we eliminate, but you would like to keep. Is that still correct?
Yes, sir.
And I'm going to keep it. 8, state did not request to take that out. 8 appears to be appropriate. There were some on both sides, and there were references to prior inconsistent statements. So I just want to verify. State, you're not asking 8 to come out, correct?
Correct.
And Mr. Summers, you're not asking 8 to come out.
No, Your Honor.
Say 8 remains. It becomes 7. Now, number 9, I don't believe there was
we
any
get that,
evidence
Judge.
of that. Mr. Summers did not testify. So, state, you're suggesting 9 comes out. Mr. Summers, are you in agreement?
Yes.
All right, 9 comes out.
Okay, sorry.
And then subsequent
Yeah.
numbers are reduced.
7. With
Yeah.
6 now being, had any pressure or threat been used against the witness?
They better wrap
7
this up
being, did the
because,
witness
you know,
some
I'm on
other
a stream
time
at
make a
12:15.
statement
I
that's
don't want to miss this.
Mr. Summers, you agree?
I agree.
Moving on from 3.9.
Well, Judge, we need to make
Oh,
sure.
yes, you're absolutely
that-
right. I forgot that it was second. It was 2 pages on the. You probably proposed 2 of them. No, all right.
I got it.
We got to take a paragraph out that says that he became a witness.
I don't know. You think they take a
It's
break
on the
before
second
opening?
page, Mr. Summers. Do you see? It's 2 lines about the middle of that.
I do.
Those paragraphs. It says the defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you applied to the
Then
testimony.
again,
of other
maybe not,
witnesses.
because the
We're
jury's
gonna
been out.
scratch that. Do you agree, Mr. Summers?
I do.
All right. As to everything else, though, Mr. Summers, are you in agreement?
Yes, Your Honor.
State no other changes proposed? Next is 3.9A, defendant not testifying, which is absolutely appropriate under the circumstances. Mr. Summers, take a look at it. Let me know if you have any objections, questions, or comments.
No objections, Your Honor. No questions. No comment.
Thank you. Next, I have 3.9 defendant's statements. There were statements that were introduced into evidence. So, Mr. Summers, any questions, comments, or objections?
No, Your Honor.
All right. Next, I have 3.9C, eyewitness identification, with specifically enumerated 1 through 9. Mr. Summers, any?
I'm more and
Objection?
more admirable of Judge Ascarati, who did
Next,
the
thank you.
entire
Next,
jury
I have
instruction review in
3.10,
what,
rules for
20 seconds
deliberation,
left?
with enumerated
Remember
paragraphs
that?
1 through 7.
Yeah.
Mr. Summers?
The
Next, thank
attorney
you.
wanted to
Next,
do
I
this
have
last night.
3.11, cautionary instruction. Anything, Mr. Summers?
No.
Thank you. Next, I have 3.12, verdict. We're going to talk about the verdict in just a second, but first, as to the content of this instruction 3.12, anything, Mr. Summers?
No, Your Honor.
All right, thank you. Now we're going to look at the verdict form, and there may be some changes based on some things that we've decided. I don't know that to be a fact, but we're going to go through each and every page of the verdict form to make sure that it is correct and appropriate. So, starting on page 1, the jury will find as to count 1, and then there are instructions, and there are choices A, B, C, D, E, and F. B, C, D, and E include the lessers that we've previously discussed. I don't think we've made any changes related to those. Mr. Summers, any issues regarding count 1?
Your Honor, is it appropriate? Is this a standard format?
It should be. It appears to be. There is a standard verdict form in the instructions. What is your issue or question?
At the end of A1 and B1 and C1, it's an attempt to use a weapon instead of the alleged weapon.
No.
Is that ambiguous? No.
It's not standard language. This is standard language on those specific things.
Okay. Then no question with count 1.
Okay. As to count 2,
Judge, the only thing is I think we need to take out as charged on the A part because he's charged with attempted first degree murder with a weapon.
it's the finding that
Makes it.
makes it.
I know.
So I agree with her. It's just scratch as charged, and then all the rest would be lessers.
Mr. Summers, any objection?
No, I understand.
All right, I'm scratching as charged. As to count 2, there are choices A, B, C, D, E, and F again.
And I think we need to
Take out as charged. Summers, Mr. Summers, agree?
Yes.
Taking that out, any issues, Mr. Summers?
No.
After that, as to count 3, there are choices A, B, and C. B is the lesser.
Understood.
And as charged remains. It's appropriate in this one because there's no special findings under A. Next, I have count 4 with choices A, B, or C, with B being the lesser. Mr. Summers?
No issues.
All right. Thank you. Next page, page 3 of the verdict form, starts off with count 5 with 3 choices, A, B, and C, B being the lesser of battery.
Judge, we need to go back to count 4 and 5. We need to do the special finding for the penetration. We can send that language to, yes, we'll send the language.
Well, we probably have it in the standard. I imagine that it's in the standard.
It's not, it's the special finding language, Judge. I can
She could just email it.
All right. Well, I just want to make sure that I read it and Mr. Summers is aware of it. and is given the opportunity to comment.
We can pull it up and read it now, Judge, and then we can send it.
All right, read the language that you're proposing be included in counts 4 and 5.
Oh boy.
Which is a special finding under count A. Mr. Summers, what that means is just like in counts 1 and 2, there's that question where the jury finds yes or no. This is going to be a question, an interrogatory type form of question for the jury to find if they select count A, guilty of sexual battery by a person 18 or older upon a victim 18 or older as charged. There will then be a question for them to answer. And that question, the language of that question is?
Judge, it would be, did the defendant's penis penetrate the vagina of Elisa Summers? Yes or no?
You understand that, Mr. Summers?
That's to the point.
Is that an enhancement to the charge?
It's for the score sheet to get the penetration points.
And
It,
then-
it can't affect your sentence, so that's why the jury has to find it.
and do we also need another?
It's an interesting
instruction
detail
in the first part of the packet with the charges?
that impacts the
Penetration or
sentence because it's
union.
not
It
necessarily
has that
automatic.
definition. That's
It
one of the
would.
Yeah.
findings in the, it's in the elements, I believe, correct?
Yes, Judge, it's one of the elements.
Can you read the language one more time? The question?
Did the defendant's penis penetrate the vagina of Elisa Summers? Yes or no? Just, it's almost, the finding is similar to the findings of the aggravation for the.
Rob is having some
Okay.
problems over here.
Any
Sure,
other
got it.
questions, Mr. Summers? I do believe it's appropriate and required.
It's a tough one.
It's just in 11.4, it says sexual organ of Trevor Summers, not penis, but I don't know if that matters.
He's a penis.
I like that. Prosecutors would love that instruction.
I prefer to be as consistent.
I would agree, Judge. Let me. That's fine. Just we would say, did the sexual organ?
So in the question, the interrogatory would, instead of penis, will say organ.
Sexual organ.
That seems less clear.
Be
That's
consistent with
ambiguous.
the
Why would you do that?
Mr. Summers,
Yes.
you all right with that?
Yeah.
I agreed.
Okay.
I still am wondering.
I don't
if we
understand.
need
What are we
an
doing?
additional
We went from something that was
instruction
clear
in,
to something opaque.
Yeah.
After
And then look at the awkward position he's in because he's not represented.
for that.
Sure,
enhancement
penis,
or
sexual
not.
organ, but whatever you like, Judge.
Or I'd like an understanding of why we wouldn't need that, just like we have the additional enhancement under.
It's not an
Attempted
enhancement.
murder.
it's
Well,
not
yeah,
an
yeah,
aggravated-
he's making a response. I'll give you an opportunity to respond to his response. So he's making a request, and I'll give you an opportunity to respond. So that's your
I
request.
mean, not to put too fine a point on
Yes,
it, but
I'm-
a penis
You-
isn't
we
exclusively a
include
sexual organ
information in the
either.
instruction.
It's used for
regarding this
excretion.
Yes, the same way.
Yep.
that
So,
there's
I mean, it's not
instruction
even
for,
inherently-
the with a weapon. This would be
Okay.
with a sexual organ.
Well,
It-
I
It
suspect their
introduces a
response is gonna
skosh of
be that
ambiguity.
One is an enhancement. This is for purposes of a finding that is on the sentencing guidelines. State, what's your response?
That's correct, Judge. So the aggravator for the weapon takes the level of the offense up a level and a degree. This does not change the level of the offense or the degree of the offense. It simply is for us to be able to get the penetration points on the score sheet.
Which ultimately could affect the sentence and thus
Day
is
drinking
required that
sounds
the
like a
jury make
strong
specific
possibility.
finding.
Correct.
All right.
Understand?
Okay.
Thank
It
you.
could happen.
You're welcome. What count were we on?
5.
5? Oh, I'm sorry. Yes,
I'm proud
5.
to announce
So
I'm
now
not there yet.
5, choices A, B, and C. Any,
special finding under A.
right, because this is the same sex bat. So the same change under A as to count 4. Count 6, choices A, B, and C. And this is going to be the same on 6, 7, 8, and 9. So, Mr. Summers, I'll let you take a look at, and then if you have any comments, questions, or objections as to the language on the verdict form regarding count 6, 7, 8, and 9.
No, Your Honor.
All right, I do have a formatting issue.
I don't get attached to formatting.
Okay, So just so you know, and when you get the final version, it's not going to look the same. You can take a look at, but the way it leaves the hanging from the page 3 to 4 is not going to be that way.
Hanging? What's hanging now?
There will be no hanging. We, the jury, as to count 10 choices A and B.
So would
There's
you
no
say
lessers.
would you say it's not?
Mr. Summers,
Understood. Thank you.
you're welcome. As to count 11 choices
I'm
A and
mature.
B, no lessers.
Yes,
All right.
understood.
All right, that's the verdict form. So
Yay!
with those changes that we discussed and agreed upon, is there any objection, Mr. Summers, to the form of the verdict?
No, Your Honor.
Next, thank you. Next, I have 3.13, submitting case to jury. Questions, comments, or objections?
It sure was.
Your Honor, I believe you read this to the jury already, correct? You would need to read it again.
No, I don't think so. This is, I shouldn't have. 3.13, submitting case to jury. I mean, there may be some similar language that was in one of the introductory, but it wasn't.
Yes, there's some similar language. I understand it. No question.
No objection?
No.
All right. That's the last instruction that will be given to them before I send 6 of them back to deliberate. I will let them know
Right,
and
Florida.
ask.
You only need a jury of 6.
Looking for my chart. Do you have an extra chart?
I forgot about that.
I'm sure mine's up here somewhere, but
I did not know that till this moment.
so we're all
Yeah.
on the same page.
They only require 12 for death
I will
penalty
be
cases.
letting number 7, Anthony Tadone, and number 8, Dawson Lefevers, know that they are alternates and they will remain behind, and I'll send the rest of them back. I'll also let them know that the evidence, the instructions that I read, and the verdict form will be coming back to them momentarily. I will give you all an opportunity to take a look at any or all of that you wish to before the bailiff
Which
take it
makes
back
things
into the
faster.
jury room. We also
That
are going to
probability
need
that jury coming today is
to
looking
have
more and
a
more
clean
probable every
computer
passing
back
moment.
there if they want to listen to or view anything. Okay. And I'll request that you show that to Mr. Summers so that he can verify any of those things, including the evidence, the instructions, and the verdict form before it goes back.
Yes, so there's no DVD player back there.
Apparently there is, but it doesn't work.
Okay.
Much
Nope,
like the equipment.
that's what we're waiting for.
2.13, did we address that? That was included in the packet. I don't recall hearing that.
I don't know. What is it? Tell me what it said.
It's the prior inconsistent statement as impeachment.
Oh,
It would have come after 2.7 in the packet.
Okay, so
let me just find it.
it's,
That was in the very beginning with
Yeah.
some like the
The Williams rule, the edited instruction, things like that. So I'll leave it up to your honor and the defendant if they want to include it or not.
yeah.
Or it was never used, so then it wouldn't be included. in
right.
the
I
final.
thought that was an instruction that's read during the trial. If it comes up, we have the instruction that talks about prior inconsistent statements in weighing the evidence. I apologize. I had it in front of me. Can you read it to me? It's up here somewhere.
The evidence that a witness may have made a prior statement that is inconsistent with his or her testimony in court should be considered only for the purpose of weighing the credibility of the witness's testimony and should not be considered as evidence or proof of the truth of the prior statement or for any other purpose. But I think you're right, Your Honor. I don't think it would have been read before this
Right,
would have happened,
right.
which it was not requested.
Right. Yeah, and I found it, and I found my chart, jury chart. So no, it's included in weighing the evidence. There is a specific enumerated that we went over, and we ultimately all agreed upon they will be instructed on weighing the evidence regarding prior inconsistent statements. All right, so the next step, I'll give you all a short break, but the next step is to bring them out, do the closing arguments. State, you have any idea approximately? Are you splitting? Who's doing closings?
We're splitting it, Judge.
Who's going first?
Miss O'Connor.
All right, approximately, I know that you probably don't have a iPhone that you can put up in front of you and stick to. necessarily what you tell me, but if you could give me a rough estimate of time, just so that I can pre-plan if I need to take a break, give the jury a break. How long do
30
you
minutes
believe
max.
total? I'm sorry?
30 minutes for me.
And Ms. Johnson, your rebuttal?
45.
Okay, so an hour and
What?
15
45
total from
minutes
the
for
state.
rebuttal.
Don't have to use all of it, but estimated an hour and 15. Mr. Summers, any
Oh, boy.
idea of how long you intend to argue to the jury?
About an hour.
Okay. And let me just tell you that that is not an opportunity for you to testify. You did not testify. It is absolutely an opportunity for you to argue your case, but your argument will be limited to any of the facts and testimony that was introduced during the course of the trial.
Yeah, good luck
You
with
can't
that.
add new stuff. You understand that?
Yes, and would you like me to address when I'm speaking of myself as me, myself, and I, or as Mr. Summers?
I do not care. That is, I am not going to tell you. I do not have any preferences. It's entirely up to you. However you wish.
Okay, I just didn't want to be construed as testifying.
Refer to yourself as the defendant. That'll be
Well,
good.
As long as you're not adding new evidence, and so if you're talking about stuff that was in evidence, including statements of yours that are in evidence, but whether you refer to yourself as Mr. Summers or I said, that's entirely up to you. Say, did you have a position on that? I mean,
No, Judge.
okay. All right, let's take.
We'd like him to refer to
I don't
himself
know
as the
how much of
guilty.
45 minutes. We took all the 45 minutes.
Yes,
Back.
it seemed to be convicted
Okay.
felon.
That'd be good.
All right. Well, is it?
About, no. just
They're
one.
back?
Yeah, they've been back since 9:30.
Also, we don't really think blue is that flattering color. We were thinking something in
2
an
hours
orange.
of jury instruction?
We only gave you 45 minutes.
All right. Okay. Well, I want to give them a short break, and we'll print all that out. What I suspect, because the instructions are very long. Okay. I suspect.
What is the
that
probability
if
that,
things go
there's
as
going to be
planned,
objections for him
I will be
testifying
giving them
during
a
closing?
break before I
100%?
begin the reading of the
200%?
instructions. They're going to have
100%.
if each side's going to take an hour, and the instructions are going to take a good part of an hour. We will plan on having them lunch at an appropriate time. It may
Members of
be
the supposed
later.
jury.
Well, we'll figure
This
that
is
out
Chewbacca.
when we determine what time we're getting started. But I suspect the plan will be to have lunch ready for them when they go back after closings from both sides and instructions from me. I don't know exactly how long it's going to
What
take.
lunch
I'm
ready for
often
them? What
accused
lunch
of
really
reading
goes
too
well
fast,
with the,
so I will
the
try,
attempted
even though there's a
murder,
lot of
kidnapping, and rape?
instructions.
Oh,
what's
yeah.
Be
what's
aware
the
of that
pairing?
and not read.
Food pairing for that one.
But it's going to take a while to read 60 pages of instructions.
Subway? They
So
always
that's
get
the
fast
plan.
pass.
The
Let's
plan
give
is
them
to give
Subway.
them a break at some point. It's most likely appropriate after the rebuttal argument and before the instructions. That seems to be the most logical time for a break. Unless either side goes longer, and then I don't want to keep them much more than 2 hours without an opportunity to go to the restroom. I hate to do it, though, in the middle of your rebuttal. You see what I'm saying? If she takes 30, he takes an hour, or an hour and 30. And if you take an hour, I just can't do that. I have to break in the middle of your rebuttal. It's like you all know the ground rules. I don't like to surprise anybody. Same with you. If you go longer, I don't have a big hook up here where I'm going to pull anybody off. But I will tell them that each side has instructed me that their closings are approximately an hour. Is that all right, State? I know you said hour and 15. I can say an hour to hour and 15. So that if either side goes 2 hours, they know that you told me that it was going to be an hour to hour and 15. Kind of keeps people honest on their estimates. So I just wanted to be all out there as to what. The other thing I tell them, I've told them before, if they need to take a break, so don't be surprised if one of them raises their hand, says they need a break. I'm going to take a break. All right, take a few
For your own
moments.
good.
We'll come back and we'll do closing arguments.
Well, there you go,
Awesome.
buddy.
Exciting.
Exciting.
and
How
fun.
long is that break?
No, I don't think I heard. I was talking over it.
Well,
15, 20 minutes?
Yeah, it shouldn't be too long. I was he hasn't seen the jury. John hasn't seen the jury yet. I said if you can at the break, but I don't really see how he can because that's a short break. He's in a courthouse. I'm just looking at it because I'm in courthouses a lot. He doesn't want to run out and then have to go back through security.
Right.
That, I mean, you're taking your belt off and all that. It depends on the courthouse, but that's a nightmare. I'm shocked because this case has some profile. Definitely, a lot of people are watching, but it's not like the Depp Heard thing. We're going back. John and I are going back and forth last night. He's like, "Yeah, I'll go over there," and he goes over. There's plenty of room. It's like a regular case. Like there's nobody else watching.
Right.
I mean, like I think John is the only person not directly related to the case in there, which is awesome.
Lawsuit is everywhere.
That is, I was really, because I messaged him last night and I was like, well, yeah, I'm gonna stream it in the morning because it's crazy, and he's been on, and I said, but yeah, I mean, it's in Tampa, why don't you go over there? And I didn't really expect him to, and he's like, yeah, it's really close, maybe I will. And I'm like, well, that'd be cool. But I said, but don't worry about it. If you just want to stream it with me, just get out in the morning, sit there in your boxers with a cup of coffee, and stream it with me and Kurt and whoever shows up.
I think we're obligated to have one of our members at the back of shot of basically all these cases now.
It is cool.
The fine Waldo moment.
It's really cool, but I do have to say, I mean, like, it just so happens this case is there. I mean, he is right there. I could tell he's like within a couple miles of the courthouse, and he's an attorney. Yeah, put your suit on, go over there, dude.
So let's see. We got her tied up. We got her moved in the car, right? While she's tied up. So that would be your kidnapping. We've got him showing up unannounced at the house, tying her up, and with pushing and stuff. So there's your sexual assault. And then our argument for attempted murder, where it gets a little bit thinner, is we had a machete, and also we might have pushed a pillow on her face. The problem with, of course, attempted murder is you have to show the intent to kill, right? That's one of the differences between attempted murder and murder, right? So it's often the case that for murder, you don't necessarily need to show intent to kill. You just need to show an intent to do an action that leads to death. And that intent can sometimes be recklessness, for example. It can be, that would be, for example, in New York, would be a very common instruction, murder 2, reckless endangerment. So you can show that. So you don't have to show the intent to kill. You just have to show the intent to create a reckless situation, which had a substantial likelihood of blah, 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 right? But to show the attempted murder, you actually have to show the underlying intent to kill. So in some senses, attempted murder is actually harder to prove for that reason than murder, because you have to show that actual intent. And the problem is, like, he had full control. He was there.
Right.
He had the machete. He had the pillow. So, like, can you prove intent beyond a reasonable doubt? Now, of course, to have the attempt, right? Once the attempt occurs, you can't renunciate the attempt. So, if you believe that at the moment he put the pillow over her face, he was intending to kill at that moment, and then he changed his mind, it's too late. So that would be attempted murder. But then, of course, you have to reach that conclusion that was the desire, and so it's a little bit ambiguous on the facts. So I think, and I have not been following the trial super closely.
Oh, I think you can beat. I think an attorney can beat the attempted murder, no problem.
Yeah,
I don't know.
So based on my understanding of where we are, I think the sexual assault, you're there. I think the kidnapping, it seems like you're there. The attempted murder seems a little thin for me. I'd be thinking about a lesser included, about basically your aggravated assault, because pushing the pillow on top of it with a machete and the rest of it, you're there, that's fine. So that's what I sort of think. That being the case, though, if the jury does convict on attempted murder, right, there's enough evidence to draw that conclusion. So you would not be in a position to reverse on a factual basis. Like, there's enough information to draw that conclusion. I'm just not sure it's the best conclusion.
Yep. It's definitely for the finder of fact on there. I mean, that's what's interesting. He messed up the intent argument. I could have talked that judge into the abandonment instruction. I could have talked him into it easily. He actually did an admirable job in saying for a pro se, and that he was trying to play with the intent issues, but he got it all wrong. He's saying, well, it doesn't matter. My intent doesn't matter. It's what she thought. No, her perception doesn't matter. It's your freaking intent. It's the mens rea. That's what counts. What he needed to say is, I'm arguing the alternative. I did not intend to do it. But if you make the finding that I did intend to do it, then I must have abandoned my plan, because exactly what you said, because I had control. I had her tied up. I had a machete. I had a pillow. I had my hands. I could have killed her. I didn't. Right. And if you presented it that way, the judge would have kept that instruction. It doesn't really matter. He can sort of make this similar arguments anyway. But he just doesn't understand. That's one of the bazillion things he didn't understand because he didn't study law.
But I've seen worse. I've definitely seen worse from pro ses, and even occasionally worse from some attorneys. So it could have been worse.
Well,
his cross-examination was very ill-advised.
That was a big debate in my chat yesterday. It's like, because he absolutely could not perfect an impeachment on a witness, and he tried 17 times. It was just brutal. But I'm
not sure whether or not he had anything to impeach with. That's he didn't. Like, he's asking questions, hoping he gets a different answer. It's like this is the difference between a lawyer and this guy, because a lawyer goes by the principle, like, you don't ask a question you don't know the answer to, and you only know what you can prove. So if I'm a lawyer asking the question, did you send the WhatsApp? And they say no. The next thing is, here is the WhatsApp. Right. This is the WhatsApp.
You don't answer the damn question if you don't have the WhatsApp.
You know? Because I already know the answer, and I can prove the answer.
That was one of the best. Like, first you get them to commit to a statement. Then you know that they testified inconsistently previously, and you have it locked and loaded. And you say, isn't it true that you gave this testimony on this date? Yes or no? Exactly. And then you read it to him. And that's the process. But it was funny. He did it to the police officer. He gets him to say something. He says something that he thinks is inconsistent, which I really didn't think was. But nonetheless, then he asked the police officer if he has a copy of the prior transcript so he can impeach him with it.
You don't have that already. No, at least in mock trial classes, they'll teach you.
John doesn't have a link, Boomer.
John doesn't have a link. Oh, Mike, you didn't give a link to John.
I did. Can you forward it to him?
No,
I forwarded it to him.
Rob's calling you out. John's calling you out.
All right. Let me do that right now. Rob, get on here and help while I send a link over there.
He's fine.
Do a little Stack Daddy dance or something.
Yeah.
All right. I'm getting it. I'm getting there right now.
I was trying to say something intelligent. That moment is gone now. But this is what you try to do if for cross-examination is, because you get total control, right? You get control, and all your questions are leading, right? There's a great video we watched the 10 Commandments of cross-examination, and I think I only disagreed with number 10. I disagreed with 9. I agree with 9.5 of it. But basically, only ask leading questions. You know the answer, and basically you cross-reference it. So if you're writing this out, your cross-examination, which you really should be doing, then you have every question they're leading, and right next to the question is a citation. The citation is where that answer comes from. So if they give you the wrong answer, and this is also why it's very helpful, if possible, to have a second chair, because the second chair can be following along with you and can have the binder, so that by the time you get to the table, hopefully they have it ready for you to present. If you have to do it solo, then it becomes a little bit follow. whatever.
Well, a lot of this you should be anticipating. You sit there and think, okay, here are the issues that I think they're going to testify about. Here are the things that I think they're likely to lie about. Although you get it in two forms. You get it organically as well. Sometimes
Sure.
I'm just, I've heard their testimony. I depose them. I have them on the stand, and they just lie about something out of left field. And I'm like, you did not say that in my mind. I'm thinking you did not say this in your deposition. And that's difficult because now I have to actually find it because I didn't anticipate they would lie about that. But that's okay.
Oh, you should always have a mark. You never know.
You should have a mark to the extent you anticipate them. But if not, you can say, let me take a second. And then you can just go there and find it and make them eat it.
Right. Now, people are asking about the jury, and I think there's some questions, so I can answer some of this. So, yeah, in Florida, unless it's a death penalty case, it's a 6-person jury, which is just the Florida thing, because Florida likes the Florida. The U.S. Supreme Court has ruled that juries have to be unanimous, but they didn't rule on a minimum number. 6-person juries are not uncommon in misdemeanor cases in many jurisdictions, but Florida is a little bit weird in that they're used except in death penalty cases. So 6-person juries is the way to go. This apparently is an all-male jury. In terms of selecting the jury, right? The law is that the big jury panel, the master panel, you start with the veneer, sometimes called. You has to be basically a representative cross sample, but it doesn't mean that the jury that you select itself has to be a representative cross sample. You have to have the exact language I'm going to get wrong, but it basically has to be a fair opportunity for the jury to be a random cross section, for lack of a better description. So as long as you're not discriminating on the basis of race or sex, for example, in the selection of the big ass jury veneer that you start with, like however many people it is, depending on your case, let's say it's 100 people, right? That you're going to select a jury of 6 ultimately from, whatever. And so you randomize it, and you select the first X people that come off the list. As long as the process is sufficiently randomized, as long as the members, as long as the attorneys themselves aren't selecting on basis of race or sex, because that would be a Batson challenge, right? You can't exclude members of the jury because of race or sex. But if you wind up just through happenstance with an all-male jury, an all-female jury, an all-white jury, an all-black jury, like that itself is not unconstitutional. It's only unconstitutional if there was bias in the way in the methodology by which it was created. But it may be, to use more modern vernacular, it's the difference between equalness and equity, right? So like everyone has an equal chance to be on the jury, but the jury itself doesn't have to be equitable and sort of the jury itself doesn't have to be a representative cross sample, as long as the process itself was fair. So hopefully I explained that adequately.
Oh yeah, that's what it is. But of course, it's always up for interpretation, and that's what you do. It's usually not. You get a veneer, you get what you get.
People are saying John is here. John backstage.
He was asking for a link. I while you were talking, I did get him a link. So if he's around, but my guess is he's in the courthouse. He may or may not have any Wi-Fi.
Yeah, fair enough.
Speak of the devil.
Good morning.
There he is.
Sunny Florida.
How you doing, buddy?
I'm doing all right. Let me know if the audio is
great to
up.
see
I tried
you in
to find
there.
a place that wasn't so loud.
Oh, that's cool. So you haven't seen the jury yet?
So no, the jury did not come out this morning. They're doing a brief break. To be honest, I don't really care about the state's initial arguments, but I will be back there certainly for the defense's argument.
Well, when did they? How much time did they say you have for a break?
They said it was going to be a brief break, so they should be back soon. But the first person, on the prosecution, does not particularly impress me, and we all know the facts of the case at this point, so there's a limited amount to what I care to hear from her.
Right. Okay, so you're going to go back in. All right. Well, here's the thing. Everybody, I guess it's an all-male jury, but everybody wants to hear a little bit about give us a little sketch after you see them, when you can, of
Yeah.
what we're dealing with the jury, especially when they go out to deliberate. Everyone's going to want to hear who, try to figure out what their deal is, rough ages and stuff like that, because that's when everyone likes to read the tea leaves when it goes out.
Definitely. But yeah, in terms of AI, I was able to listen in a little bit on what was going on this morning from you guys. But in case anybody's interested in my opinion on how they handled it, I actually thought Summers did a decent job for somebody who doesn't know what the hell he's doing in terms of the jury instructions.
Right.
And I was actually really not impressed, particularly by the prosecution, because they're the ones that provided all of it, and it was full of typos and BS nonsense, which is why it took so long.
Yeah, but that stuff happens. That's pretty typical, to be honest.
I mean, it's not necessarily easy, but I don't know. At least in New York, when we did civil trials, it was basically just a box of like index cards that they would just pull out and put in a pile.
Yep.
But
I did like the portion when the judge was warning. I like the portion when the judge was warning the prosecutor about the abandonment instruction and being like, basically saying in so many words, "Are you sure this is what you want? Because I think you're right, but this is basically principal grounds of appeal. So you could just change your mind and moot the issue."
Which was the instruction?
For the abandonment instruction.
Oh, I agree with Mike. I did hear him talking about it a little bit. I could have won that. I mean, he was trying to argue in the alternative. He just doesn't know how to do it.
Right.
I mean, I don't see why that's
warning the prosecutor.
instruction.
All right, so you were sitting right next to the victim. Did you happen to talk to her at all or anything? I know you're like not trying to, but like, did you happen to just inadvertently say hi or something like that?
No, I did not. I intentionally did not.
Right.
But look, I think definitely the victim's family is all there, and they seem to be doing okay. They've got comfy cushions for those church pews.
Yeah. Oh, they do?
Very much.
Oh,
Well,
Right, I have
they
my
brought their
stack
own.
Here, you should have been provided the stack.
all right.
with the changed
They're
instructions.
coming
You
back.
will
Let me see.
have
Let me
time,
pause
as I
it.
indicated before, I read them to the jury.
All right, I'm
so
gonna start heading back to the courtroom. Then I'm gonna grab a quick cup of coffee, and I'll let you know whenever they let the jury out for a break. I'll touch base again.
All right. Thanks a lot. That is so awesome that you're checking in.
All right, guys. Have a good one.
All right. That is so cool. LawTube strikes again, and in typical LawTube fashion, like half-ass at the last minute. I didn't know about this case until like the night before last, and then I like start halfway through, and then we get into it. I'm like, John's like, the courthouse. I'm like, go in there. All right, let's get back to the trial.
Let's get the jury.
Let's get the jury. That's a good plan.
Sign the lunch. Are we getting them lunch from the counter again?
I think we have to one day.
No. Let's get the state its half hour. Let's get this guy his hour. And then I'll do my stream on the Trump affidavit, which I'm sure will be disappointing, but we'll do it anyway. A lot of news out of Florida today.
Florida's a happening spot. No, I think we get a verdict on this today. I think he's guilty on all of them except attempted. But I think he gets rung up on that too because he represented himself.
I'm just gonna on the fly here change that to the parties will now present. Any objection, Mr. Summers? If you're looking at 2.7, it says the attorneys now will present their final arguments, but I'm going to just say the parties.
No problem.
Ms. Johnson? All right.
That's his former attorney behind him.
Jury is present and seated. Everyone else may be seated at this time. Gentlemen of the jury, welcome back. First and foremost, I do apologize. It took a little longer than I expected. I take full responsibility for that. Do not hold that against the parties at all. You will see after the instructions and I
blame the parties.
that I give the instructions that they are lengthy, and that's what took a while to I needed to make sure that they were all appropriate and correct. So we are now at the stage of closing argument, and I have one very brief instruction before the closing arguments. The parties now will present their final arguments. Please remember that what the parties say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has given his closing argument. State ready to proceed?
Yes, Your Honor.
All right, Ms. O'Connor, you may proceed.
Bring it.
May it please the court, Mr. Summers, co-counsel, gentlemen of the jury, a nightmare that Elisa Mathewson has had to relive for 5 years now. To relive in front of you, testifying here during this trial. Relive the traumatic events that she was forced to endure by that man, the defendant. What this comes down to is a scorned lover. The defendant was not willing to come to grips with his divorce with his ex-wife. If he couldn't have her, then no one could. And that is what leads us to what happened March 11th through March 13th of 2017. The judge is going to instruct you, and you will get a copy of these in regards to the charges. In order for the state to prove the crime of attempted murder in the first degree premeditated, the state has to prove to you these 3 elements. Trevor Stephen Summers did some act intended to cause the death of Alyssa Summers that went beyond just thinking or talking about it. Number 2, Trevor Stephen Summers acted with a premeditated design to kill. And then number 3, the act would have resulted in the death except someone prevented him from killing her or he failed to do so. You're also going to receive an instruction for aggravation of the attempted first-degree murder with the use of a weapon. The facts are clear. You heard from Ms. Mathewson after the second act of sexual battery against her by the defendant, he makes her shower. He then has her get back onto the bed. He leaves the room. He's gone for some time. She can't say how much time, but he's gone for some amount of time. And then he comes back in and, quoting Ms. Mathewson, "All I saw was an expression of evil and hatred. And at that time, I thought he's here to kill me. I'm going to die." And as she sees that look on his face, she notices he has something he is hiding behind his back. He then comes over to her as she is on the bed, tied up, and puts the pillow over her face. She starts struggling. So what does he do? He then gets on top of her, straddling her, applying more pressure to that pillow, to the point where she is thinking to herself, she knew where she was going. She was going to meet Jesus. And then she loses consciousness. And we know he did this because he admitted to that to Sergeant Remia in his post-Miranda statement. And we know that he stopped and took the pillow off of her. Otherwise, we would be here for a different case. There was no heat of passion. One of the additional instructions as far as the attempted murder is that you will see that it is not a heat of passion. This is not a heat of passion. He knew exactly what he was going to do when he went into her room while she was tied to the bed. Keep in mind, this was hours after he had snuck into her house, shortly after 12:30 that morning. Hours after he had lingered in her home for several hours before waking her up in the middle of the night. After numerous times where he ties her up with rope, Christmas tree lights, a vacuum cord, there was no heat of passion.
I didn't know about the Christmas tree lights. That's a nice touch.
Oh, he brought it all out in his cross.
As to count 2,
I
for
don't
the
like
attempted
this.
murder,
This is not good.
this was from March 13th, where they get to Little Harbor. He parks by a dumpster near the Hooks restaurant. We heard testimony from Ms. Mathewson that he is in the driver's seat. The defendant says that he needs to write a letter to his parents. So what does he do? He climbs into the 3rd row, gets directly behind her, who's in the 2nd row. And keep in mind, at this time, she's tied up. She showed you, she's tied up with the rope around her body with her hands up in a clenched fist-like fashion up around her chin. If he really needed to write a letter to his parents, why go to the 3rd row? Submit to you. We all know that that's not why he was going to the 3rd row. He had already written all the letters. You had heard testimony from Ms. Mathewson that happened well before they were at Little Harbor. He went to that 3rd row with the intent of pulling that rope and strangling her. State's Exhibit F5. We see the rope that was tied around Miss Mathewson's arm that was used to tie around her body, and the rope that was then used to strangle her.
Yeah.
Looking at State's Exhibit F6, this is a close-up of the rope tied to her arm. And then if you go back and look at the photographs that were taken by crime scene at her house, Miss Mathewson's house, the rope that was found in the trash can, and this is in State's Exhibit Set 1, A38, we see the black rope in the trash can. The exact same rope. The rope that you heard Miss Mathewson say she saw him pull from his pants pockets the early morning of March 11th of 2017. He went to her house with this rope. Why would you go to your ex-wife's house with rope if all you're doing is intending to talk? State's Exhibit K3 shows you the linear line on Miss Mathewson's neck, on the left side of her neck, and K4 showing how that line goes around to the back side of her neck. And those are the photographs and observations that Ms. Hall, an advanced registered nurse practitioner who conducted the sexual assault exam, as you heard testify, observed on Ms. Mathewson. And you heard Ms. Hall say that these types of marks can take up to 24 hours to appear. So while you may see it on the left side at the time in which she did the exam, it's possible that there could still be some marks appearing on the right side of Miss Mathewson's neck based on the strangulation with the rope. You also heard the testimony from Ms. Hall that the linear line is consistent with that coming from a rope. And then what else did she say? That it had to have been applied with enough pressure to leave that mark. Again, this was no heat of passion. This was premeditated. He had no intention of them leaving that vehicle at Little Harbor. By the grace of God, what he thought to be an undercover vehicle drove by, and he got scared. He failed to follow through with what he intended to do for a second time. As to count 3, we have the kidnapping incident from the Walgreens. Go back, listen to that 911 call from Mr. Crosby, Exhibit C. Consistent with what he testified to here the other day. We heard testimony that once they get to the Walgreens, the defendant parks the car away from the store. He goes into the store. Remember, her hands are tied behind her back. And she still had that blanket over her shoulders that he put on before leaving the house. She's somehow able to move her arms a certain way to unbuckle herself and then open the door and get out and try and run. And she told you she ran to the main road because she knew she couldn't go in the store. That's where he was at. Hopefully thinking that somebody driving would help her. Unfortunately, the defendant saw her running out of the car and she wasn't fast enough. You heard Miss Mathewson testify that he grabbed her, picked her up, forced her back into the passenger seat as she is struggling and fighting to keep him from putting her back in there, because she knew what was going to happen if he was able to get her back in that car. And then he drives off. You heard her testimony that she was able to get the door open one more time as they're driving. He stops the car, then buckles her up, ties her, and slits her wrist, saying that's for trying to run away. The defendant admitted to Sergeant Remia that she ran. He went out after her, grabbed her, put her back in the car. He even admitted that her hands were still tied behind her back. And then he tied her to the seat. He goes on to describe how from there, because now most likely the authorities are going to be contacted, that there's no way they're going to be able to go to his house and say goodbye to the children. So he drives for several days through Manatee County and Hillsborough County. In the kidnapping instruction, you will see for element number 3, the state has to prove the act was committed with the intent to commit or facilitate the commission of a grand theft of a motor vehicle. And that is in count number 10 as a separate charge. And the state submits to you that the grand theft motor vehicle started when they left the house before going to the Walgreens, because we know her hands are tied behind her back. We know she's not the one driving her vehicle.
Yeah, I think she's doing fine.
The defendant is the one who took the
I do too.
puts her in the back seat and drives. We also know from his own statements, again, that he is the one who drove throughout Hillsborough County and Manatee County for the next few days, throughout the 11th, the 12th, and the 13th. At no point in time did Ms. Mathewson ever drive her own vehicle during those 2.5 days. One of the elements as far as the grand theft motor vehicle that you will see is that the defendant knowingly and unlawfully obtained or used or endeavored to obtain or use the motor vehicle. Well, we know he was using it. He didn't have permission to do so. And temporarily or permanently deprive. 2.5 days where she doesn't have access to her own vehicle. Several times throughout, she is tied either to the car, the captain's chair in the car, or tied herself. The state submits to you that the kidnapping facilitated the theft of her motor vehicle. Now, as to counts 4 and 5, the sexual battery, the state's required to prove to you 4 elements. And I submit that elements numbers 1, 3, and 4, those are not at issue here. We know that the defendant, per his own statement, had sex, according to him, with Miss Mathewson.
Mm-hmm.
And that his penis penetrated her vagina. We know that they're both over 18. The issue is element number 2, consent. So let's look at the definition of consent. It means intelligent, knowing, and voluntary consent, and does not include coerced submission. Consent does not mean the failure by the alleged victim to offer physical resistance to the offender. The state does not have to prove to you she tried to fight him off. The state does not have to prove to you that she said no. You broke into my home in the middle of the night when I was sleeping, attacked me, and tied me up. I call
Yeah, that's
that
kind of unambiguous on that one.
It's Matthewson's words just the other day.
Yeah.
She's doing a nice job laying it out.
Yeah, I do like it. I like the way she's using the previous testimony, exactly what you're supposed to do, right?
She
Use
felt
previous testimony, use previous evidence, previous facts. She's laying it out charge by charge. I think she's doing fine.
that she had no other option. And I want you all to go back and pay close attention to the defendant's post-Miranda interview. Because
What did we say about this
every
post-Miranda
other
interviews? What have we
time
said, Mike?
the defendant talks about having sex,
I don't know.
he describes it as sex.
Don't talk to
We
the
had
police.
sex. We had sex.
Well, yeah.
Pay close attention around the 15-minute mark when he describes the sex that occurred on March 11th of 2017. He says,
I'm thinking about an hour.
we had
I don't know how
sex
to do a
4
poll.
times, consensual. It wasn't
I don't think you
forced.
can do it inside StreamYard.
Nothing.
You'd have to go into YouTube
Completely
back end and do the
consensual.
poll.
The one and only time that he described it as being consensual. Why is that?
It is STFU Friday. Thank you, Peg Leg Fiance, for catching the reference.
Counts 6 through 9 is the child neglect of the children. And I'm not going to put up all of the instructions because they are all the same. It'll just have the different initials for the children. But the state is required to prove to you 3 elements: that the defendant willfully or by culpable negligence failed or omitted to provide the child, in this case, this is going to be for Arden Summers, with the care, supervision, and services necessary to maintain Arden Summers' physical or mental health. He was a caregiver, and then at the time, Arden was under the age of 18. There's no disputing this at all. We know for a fact he let his 14-year-old daughter drive home, about a 26-minute drive, from Miss Matthewson's house to his house around 6 o'clock in the morning. You heard from Arden Summers, she didn't even know where she was going. Luckily, she knew how to use the navigation system in the van. And then once all the kids are home, there's no adult. You have Arden and her other siblings, Bryn, Grady, Landon, and Cooper, all home until about 3 a.m. on March 12th, when law enforcement knocks on the door of Carol and Stephen Summers, asking one of them to go over to the house because there's no adult. And prior to even Arden arriving back at the house with her siblings, We know that the defendant had left the youngest child, Cooper, who was 3, at home all alone because he was asleep. As to count 11, we have the violation of the DV injunction, the domestic violence injunction. Again, there is nothing in dispute with this count. The interview the defendant provided to Sergeant Remia, the video that the defendant made on Miss Matthewson's phone is Exhibit Y. And we have the order of the injunction and service on him, which was Exhibit AA. So the evidence that you received in this trial is overwhelming, but all of it, the 911 call that was made by Mr. Crosby, the Walgreens video, the text messages that were between Arden, Landon, and the defendant, the videos the defendant made, the confession letter he wrote, the letter he wrote to his kids, states Exhibit S3. Where he says, "We wish you the best in everything you do, and we'll be watching you from heaven." His own statements to Sergeant Remia. The testimony from Deputy Cruz of Miss Matthewson when he was able to extract her from that vehicle, the sense of relief on her face, how frantic she was, how upset she was. Of course. The ordeal that she had went through, and the relief was because she knew if nobody had found her, she would be dead. I want to talk a little bit more about the defendant's post-Miranda statement to Sergeant Remia, as there are additional statements he made other than what I have already discussed with you.
I wonder if she's making a point of it being post-Miranda for some sort of tactical reason.
Contradictory to what the defendant claimed, this is not a situation where you have two individuals who are quarreling over a divorce. His comments to Sergeant Remia about how it messed up his mind, she was messing with his head, is nothing more than, again, him not wanting to accept the fact that their marriage was over. There were no mental issues or health issues that the defendant was having. This is not in an insanity case. You will not get an instruction on that. And that is not something that you should consider. There is nothing wrong with him mentally. He just could not get over the fact that she began dating. And according to him, was lying about it. And that's what made him upset. Gentlemen of the jury, shortly after 12 a.m. on March 11th, 2017, when the defendant snuck into Miss Matthewson's house in a window on the side of the house, not through the front, on the side. He did not have the intention of just talking. You don't sneak into somebody's house in the middle of the night with the intention of just talking. I submit to you, he also never had any intention of either of them getting on a boat and going to the islands. His intentions were for her at first never to leave that house. And then when that didn't work out, to never leave that car at Little Harbor. The state has presented to you an abundant amount of evidence that proves beyond a reasonable doubt the charges in which he has been charged with.
I like it. I like it simple, to the point, not overly long, which is a massive sin of too many lawyers.
Yep.
Her
She stuck to about her time
better,
frame that
but
she said.
yeah, I'd give it about 7.5 out of 10. I think it's great. Now let's see how this goes. This should be fun. and
Oh,
exciting.
oh, here we go.
Your Honor, good morning.
This ought to be
Good morning.
something.
Good morning, State. I'd like to just be able to share with you a re-representation of what we've heard over the last week. And I'd like to start with just helping you understand from the details that were given and consider that the condition of both myself and Mrs. Mathewson were not adequate enough to truly paint a picture that you could understand. If you recall, we spent a lot of time that weekend just talking, just trying to figure things out, wrestling around, fighting about a variety of issues. Some of them you heard about, some of them you haven't.
It was mostly
But
peaceful.
you do
weekend.
remember that we didn't sleep very much. Our emotions were all over the place. Our stress was high. You've heard these things through her testimony and through statements of others in this case. And so I ask you to please keep that in mind as you look through, as I walk you through the facts that were presented. I first ask you to pay attention to the photographs. As you walk through the photographs, I ask you to please look through them and notice things in the residence of Mrs. Mathewson. That there were no signs of a struggle, that there was not broken glass or dents in walls, there's not scratches on countertops or blood splatter. This was not a scene that depicted some kind of crime or some kind of anything more than what she described as wrestling around.
Well, you didn't have the
more than
victim tied
You can
up.
see that the things aren't thrown
Describe it a
about
little bit
as
more
she
than that.
described. Things are where they're supposed to be. You can see that we packed, we left, and we had a plan to go to my house. Her accusation is that she was tied to go to my house. But I ask you, does it make sense to go meet children with a woman tied up? I also ask you to look at the items that were disturbed by law enforcement during their 3 times investigating that home.
He didn't lead with
There are a number
I
of
didn't do
things,
it. I'd like to take
statements
note.
that were made, including a variety of
Kinda telling.
articles within the home that weren't brought in front
I
of
want you to take a look
so
and
that you
see it
can't
doesn't
make
look like
conclusions,
that.
so that you
Not
can't
that I didn't
corroborate
do it.
the stories or the statements that were made here.
Yeah.
I ask you to look through the pictures of the vehicle. I ask you to consider that they don't line up with her stories either. Little things like the pancake platter sitting in the second row and not the third. Little things like a purse being full of all kinds of contents that were helpful to her, useful to her, that she didn't really need if the whole intent to take her somewhere and kidnap her or steal her car. Why would she need her purse? Why would she need her phone? Why would she need her charger? It doesn't
What?
make any sense. And I also ask you to look at the car handle. The car handle's far up in the front of the door. And her statement is her hands are tied behind her back. I think most of us understand that if you lean your back against the car door and you pull the handle, you're going to fall out. You're going to tumble on your head. But she didn't say that happened.
Especially when you're tied
I
up.
also ask you to look at the pictures of Mrs. Mathewson. You'll see the full pictures when she was evaluated and examined after these events. You'll see that the bruises line up with wrestling around. You'll also see marks, bruises on her arms where she said, I lifted her up through a ravine. And you'll see exactly that's true. We pulled her up through a ravine. You'll see that there are blisters on her heels. Again, I mentioned to you guys, or I questioned her about why she didn't put flip-flops on, or why she would put shoes back on if she already had marks on her heels. And her answer was non-responsive. And so,
Objection, Judge. Inappropriate misstatement of the facts.
Hold on.
Ruled.
Well, I'll instruct the jury at this time that what Mr. Summers says during closing and the attorneys during their closing is not evidence in the case. I will instruct you to rely on your own recollection of what the testimony and evidence was.
gentlemen, if you remember, we walked through those fields for hours in muddy conditions. Those shoes, as Ms. Mathewson testified, were getting stuck in the mud, and clearly that's what caused the blisters on her heels. You won't see any kind of rope burns on her wrists or her ankles. They're not there. You also won't find any photographs of anything after that. The law enforcement failed to investigate anything further beyond Ms. Mathewson's condition to see if another bruise would show up on the other side of her neck, or if any bruises or marks would show up anywhere else. That would have probably been a normal thing to do.
Normal for you, maybe.
And you'll also see that we physically fought each other. I don't argue that with you.
Good. That's good.
And I also ask you to look at the photos of Mr. Summers, of myself.
I don't argue that we physically
You'll
fought.
see that I was
Plus.
in no condition
Yeah.
to be interviewed by the police.
That's all but the attempt right there.
If you were in that position, you would feel vulnerable. You feel taken advantage of. You see that I was restricted, I was captive, and possibly coerced.
You
And
were?
I argued that. Aside from the pictures, gentlemen, I ask you to look at the videos. If you look
He was
at
bullied by that tied up woman.
me at Miss Summers' house, I'm in a confused state of mind.
Yeah.
We're going through a divorce. We don't know what's going on. I questioned Miss Mathewson about our conversations about her pregnancy, and she recalled some things that we had talked about. This was something that I want you to consider. I also want you to consider a very special moment in that video where I'm asking Miss Mathewson what else she would like me to say. I submit to you guys that when you're in these kind of positions, you can clearly see through the complexity of this evidence and through the variety of it, how the emotions are all over the place. I also asked you to look at the Walgreens videos. Mrs. Summers goes into, or Mr. Summers, myself. I go into the store, but that's the opposite of the state's witness. He doesn't see me go into the store. He doesn't even know where I came from. That's his testimony to you guys. He doesn't know what kind of clothes I'm wearing. He doesn't know what kind of clothes she's wearing. But this is the main witness that's supposed to identify that the one single thing that he saw was her hands behind her back. He said her hands behind her back. I don't know how she ran out of the car, but were they tied? You have to make this decision. Again, I point to you, how do you get out of the car, your hands tied behind your back, and open a door and not fall out? I also ask you to look at that Walgreens video and see that it was parked right in front of the store. If someone's held captive in the car, I don't think it's logical that you would park right in front of the store. I think you would park somewhere where no one else might see that. I think you would probably
You might have not been fully
park in a
thinking.
different way so that if you needed to, you could
And
get out.
criminals do stupid things all the time. It's how they get caught.
The testimony was that the vehicle was pulled directly in front of the store, head first into the parking spot. I also ask you to consider looking at the vehicle not speeding away. There was no rush to leave there. It wasn't that much of a concern. It was a moment of panic. As you also look at the other videos,
You're not saying you
please
didn't
look at the McDonald's video.
break into her house. You're saying you broke into her house and
Mrs.
talked to
Mathewson
her.
was free to leave.
Okay.
It was a
But
perfect
you broke into her
opportunity.
house.
This
Okay.
is true. If all this weekend, after 50 hours, all of these things were true, what better opportunity than there for her to leave? She had the opportunity to order what she wanted. She was not being held by myself at all. Now, I know the video played with a little bit of choppiness earlier. I'd ask you to watch it again and see if you can get it to play smoothly and see that
Could be worse, is all I'll
this is
say.
a agreed upon situation. We're in there together. We're getting breakfast. We're moving on.
It would help a lot with I did not do it.
I also see that she is cooperative with me.
Instead of look at the scene,
She's
because there's
using
no
her
broken
purse. She has
bottle.
the contents of that purse. And
Rob is
there's
exasperated
no
in the
issue that
background, by the
whole
way.
time, almost 2 minutes, maybe even more, of going through that drive-through. Logically, I would not be able to get out of that vehicle. I had a seatbelt on, and my door would immediately hit the building. And again, a great opportunity for her to leave. As you look at the Sitco video, there are 3 videos on there. 2 of them show me inside the store. One is from a different angle where you can see that the vehicle is not parked at the first pump. I ask you to look at that. Ms. Mathewson states that I pulled as close to the store as possible and right next to the first pump. That's not true. I didn't have any concern about where I had to pull close in proximity to the store. You can see that from her vehicle where her gas tank is and where you have to pull into the gas station. It's just logic sense. You can also see that I was there for inside the store for a number of minutes. And then again, another opportunity for her to just walk away, run away. I remind you guys that this is 6:50 in the morning on a Monday morning. There's people all over the place. It's rush hour.
Objection, Judge, facts not in evidence.
I will instruct the jury again that anything that Mr. Summers or the attorneys for the state say is not evidence, to rely on your own recollection as to what the evidence was in this case and testimony that came from the witness stand. I will instruct you, Mr. Summers, to avoid arguing
Very
things at this
unnecessary.
time that are not in evidence.
Gentlemen, just remind you that they showed the time on the receipt of the McDonald's slip and that it was a Monday and it was just before 7 a.m. Also, then ask you to consider the testimonies of the people given. The first is Randall Crosby. Again, he does not recall where I came from. He doesn't not recall what clothes I was wearing, what clothes she was wearing. His statement is pretty inaccurate. He doesn't recall what vehicle it was that was 15 feet from him, even though the name and the insignia is right on the back of it. Only he was focused on was getting that license plate. He was paying attention to that, not what was happening with us. I don't understand how he could be able to look at the vehicle and get the license plate at the same time pay attention to what we're doing. He was also on the opposite side of the vehicle in orientation. He's standing by a red box machine. As you look through the videos, as you look at the overall of that store, you'll see that his position was not a very good view of our position, of Mrs. Mathewson running away, of my position coming out after her. He did not chase us. He did not follow us. He was also the only person standing outside at that time. You'll see a few other people walk into the store a little bit later. All of these people were also available to Ms. Mathewson to go and talk to. If I'm in the store, she could have went and talked to him or tried to seek help from him. He also, in his 911 call, you can listen to that, it says that he didn't even know the street location of where he was working. He didn't know that the place of his employment in his testimony, or what time he started the shift, what time he ended. He was also not close enough to hear the things that were being yelled at each other. Mrs. Mathewson said that she yelled. We were screaming at each other as we were going back to the car, but he couldn't hear that. I then point to you to Kimberly Shea, who gave you a very accurate evaluation of what she saw. Her statement was true. She was pulled in directly across from the passenger side of that vehicle. She saw the emotion on Mrs. Mathewson's face. She saw that we were in some kind of an argument, some kind of a torment. And she also saw Mrs. Mathewson's hand. She saw her hand leaning on the door sill and leaning up against her face. That wouldn't indicate that her hands were tied at all. I also point you to Ms. Shea's knowledge of the exact type of vehicle it was from the moment that she saw it, color, the position, how far she was exactly from the vehicle, and that we left. Then we go to David Chesla, Dr. Chesla. Dr. Chesla did not operate on me as he stated. He also doesn't remember even seeing me. He could not tell exactly what time and what type of medications were given to me. He's only assuming from some records that he may or may not have been involved with. He doesn't know what the volume of the doses were or what types of medications could have had. He didn't testify to what kind of impact those combinations of medicines could have had. He did not speak with law enforcement, and his responses were quite vague. Then to the other medical professionals that testified. Teresa Wagner, Rita Hall, and Francesca O'Neill. They were all involved in some kind of DNA analysis or some kind of evaluation of Mrs. Mathewson's injuries and the sexual battery kit. And again, that sexual battery kit, the test came back, no evidence of rape pointing to me, no DNA match to me. And this happened immediately after the alleged sexual encounters. This didn't happen after Miss Mathewson showered. Her allegation is that this happened on Sunday, and this test happened, and the rape test was given to her on Monday. It also, they also tested the clothing.
Yeah, there's no DNA match, but we admit to the sex. So,
and none of that tested positive for myself being in contact sexually with Miss Mathewson. The sheet from the bed tested positive for my DNA, which the analyst said could have been there that day or sometime prior to that. As you know, from Miss Mathewson's testimony, we were in contact prior to the 11th of.
He confessed multiple times to having sex with
I
her.
also ask you to consider the testimonies.
yeah, so the lack of DNA is kind of
they were not a
doesn't
witness to
matter.
anything prior to simple peaceful arrest. I did
yeah.
not resist. I do not see, not have any testimony of me.
Again, a good argument if you
Or
didn't screw
acting
yourself up with the confessions.
rational way with them when I was arrested.
Don't talk to the police.
They did not attempt to investigate, despite all of this available DNA, fingerprint analysis, things that could have corroborated the story, maybe made it a lot more sense for you. But they did not attempt to test the pillows to say, yes, this is
crazy psychopath.
evidence of her accusation. They did not attempt to test the Christmas lights to see if there's any trace, as the fingerprint expert testified to see if there's anything on the glass bulbs or any kind of skin, any kind of anything with these Christmas lights. They did not attempt to test all of those items in the vehicle. I asked Mr. Becker, could this have been tested? Could this have been tested? And it was their position that, yes, it could have been tested. And if you think about it, think about all the things, and you look through those pictures, look at all the things that were in those vehicles and line them up with Mr. Mathewson's testimony and see, would those things have some value? I believe you would find that to be true. I also believe that the contents in the trash can, the rope, they collected it, but it was not tested to see if there were any kind of skin or DNA evidence on that rope. That probably would have been a good thing to do. They did not check the NyQuil bottle, the other bottles, the broken wine glass. Look at all these things. They did not check to see if any of those produced.
To what point? To what end? What would be the point of testing them?
Corroborate the allegations against me. So you have to ask
Are you
yourself,
claiming
what
there's someone
reason-
else's DNA there? What's the point?
They also did not check anything about this statement that they collected from me in a hospital that was taken after, again, you know that high dosage of medication was given to me. They did not check to see if there were boat charters on any kind of schedule or any kind of thing that could have even corroborated my story there. They did not check
Yes,
to see
that's
if I
her.
had offshore accounts. They did not check to see if any of these directions that I'm giving, if you listen to that interview, I'm talking about this road and that road. I don't know. Maybe you guys are familiar with the area. Maybe you know.
Objection, Judge.
I will instruct Mr. Trevor, not to place the jury in your shoes or the shoes of any party. Don't make arguments like that where you to the jury.
Okay.
You can argue the facts, but
Okay.
avoid what you just did.
Gentlemen, I would just assert that the law enforcement did not check to see if these directions even fit to a map. And they also didn't seem to think that the statement about immigrants was a little bit out of whack.
How the immigrants
I
get
encourage you
into
to listen
this?
To that video or that audio.
How do they get drug into this nonsense?
And see if someone really does sound like they make sense, or if they sound like something different, in fear, in panic, concerned. Look at the condition that I'm in, look at the medication given, and please draw a conclusion from that. I also submit to you that law enforcement failed to recognize any red flags or false statements regarding if I owned a house and if I was able to just sign it over to somebody. If I owned a car, I'm just able to sign it over to somebody. Or even if the passwords to the bank accounts were valid or not. These all would have been important for you to make a decision about whether or not I was giving correct information.
What?
The police also purposely did not interview me when I was awake, sober, clear-headed, recovered. They only interviewed me one time at a hospital where I was vulnerable. That's it. There's no other time. They didn't come and ask me later.
Did they give
I
you
could
Miranda?
please
Did you
explain
say
things
yes? I'd
better
like to
them.
talk
They
to the
didn't
police very
come with a
much.
written statement, ask me
Let me
to
sign the
sign it.
card. Did you do
They
that?
didn't try to attempt to get any other information from me. They thought case closed. He said what he said. And that's it.
Well, you confessed all
I
the
also
crimes.
submit to you that law enforcement
That kind of
made no attempt to follow up on the marks on either side of Mrs. Matheson's neck. Again, they took some basic statements and said, "Oh, you know."
I think he
you know,
probably
we
talked
can-
me into the
we're just
attempted
going to,
murder charge. I have to be honest.
conclude here.
It was iffy for a
I-
while.
Also,
I had more doubt.
could have
I had
taken
more doubt before he
items
started
into
talking.
evidence to fill the holes in the story and to corroborate this story. And I believe that would have been much more helpful for you to make a decision in this matter. Then we turn to the children.
Yes,
They only said a
absolutely.
few things. I didn't ask them much.
It's
I didn't
hard, but
believe
it's
they even,
possible.
said too much of value, but the little bit that they did say, it contradicted their mother being dragged down a hall in the house. It contradicted what their mother said about being restrained in the corner of the living room. It also shows that mother had no interest in speaking to them when the oldest Arden came
Is
into
mother
the
the
home,
victim?
while the youngest two were into there.
Sure is.
There was no information given to them. There was no concern to them about while Mrs. Matthews and I are arguing and fighting in the home.
What a
And then we
strange
turn to the
phraseology.
statements of Mrs. Matthews. These statements were outrageous. The statements were exaggerated. The statements were, most of them, impossible. The responses to simple questions were abrupt and over the top. The calm answers, if you recall, they revealed some truths, such as wrestling in the living room. That's a true statement. Such as sleeping in the car. That's true. Such as not caring about sex. That's true too. Such as just calling it sex. That's true. About being woken up by water droplets rather than some other crazy way. If you guys remember the timeline that was presented, they say that I came to her house at 12:30 in the morning. And she finally woke up around 3. Text message showed between me and my children, and I'm trying to wake her up. Showed that I tried to turn on the television loud, I tried to put lights on and off, tried to slam some doors. I think you guys can understand that. I also ask you to pay attention to the statements that Ms. Matheson made. She drove to my neighborhood after these prior allegations. She said nothing to our children to help her in this alleged situation.
To her minor
She was
children?
already in
She
the
didn't say
bedroom,
anything to the minor
and she made no
children?
statement
That's your
of
defense?
being drugged back into there. She claims an entire bundle of rope fit in my jeans pocket. That rope, again, was not tested to see if used in any allegations here. She claims that there was a sock in her mouth, but does not recall those details. And as you go through the evidence, you'll see that no sock was recovered.
A sock in
You'll
his
see
mouth
that
would be a good
no
idea
sock
right
was
now.
tested to corroborate this.
Mm.
She claims that duct tape was on the mouth, but again, nothing corroborates this. You have a picture of duct tape. You have a very simple thing that law enforcement could have tested and said, yeah, what she said is true. That's duct tape. You also have a statement about
That's a fair point.
predominantly calling it sex.
Criticizing they didn't say it, he can't.
And then has a cigarette after each time. She offers no details like in the other accusations. They just had sex and we move on. She also says that she was screaming when she came back to the vehicle at Walgreens. Again, no witness made this kind of observation. She says that she opened her car door with her back to it and did not tumble out on the ground. She says that she refuses to recall the majority of the time we were together over the weekend. If you recall, we were together roughly 30 hours apart in the country, in the woods. But she can't remember most of the conversations that we had.
No, probably
She
not.
also says that we were driving around on Monday morning between the hours of 6 a.m. and 10 a.m. on some very busy roads. But she made no effort to signal another car or really elaborate on any of that time for you. She also states that we argued throughout the weekend. And that should truly help you understanding the range of emotions that were happening, the things that were happening in a divorce situation.
Objection, Judge. Facts not in evidence.
Again, I'll instruct the jury to rely on their own recollection of the facts were. I'll caution Mr. Summers to please avoid arguing or referring to any facts that were not testified to in this case.
Then we'll go to my interview. If you
let's
evaluate
do.
me on this statement made in the hospital, I hope you find that it doesn't make much sense. I hope you find that there are a glaring number of issues, sometimes in, sometimes out. Things about, again, bolts and incongruent driving directions, about immigrants, about a variety of things that really show a concern for the situation I'm in. So please evaluate that based on the conditions that you know surround that interview. Aside from this, gentlemen, I just remind you that from the beginning, I've assumed my presumption of innocence. And
Yeah.
I maintain this until now. I assert that the state has not proven what was in my heart, especially regarding 2 counts of attempted
Objection, Judge. Inappropriate requirement of the state.
No, that's fine.
I'll instruct the jury that what Mr. Summers say is certainly not the law. In this case, the law will come from me and the elements of the crimes will be contained in that law. Mr. Summers, restrict your argument to the law and the evidence in this case, please.
Yes. I'll rephrase that, gentlemen. The state has not proved my intentions. They have not proved that I intended in counts 1 and 2 to kill Mrs. Matherson. In my statement in the hospital interview, I clearly never said I intended to hurt her. If you're relying on that, that's fine. I never said I intended to kill her with a pillow, and I never said anything about the rope. Never mentioned the incident one bit. I'm also going to assert that they did not show any intent to steal a car. They did not show that that was the underlying reason that Mrs. Mathewson went with me. They did not show me that I intended to kidnap her. There's a lot of holes in
No,
there,
just showed that you actually did both
and
of
I
those
ask you
things.
to please consider
Mm,
when evaluating whether or not you find the facts true. They also did not show my intent to take advantage of Miss Mathewson in any sexual way. The way I've described it in my interview, you've heard the way she's described it, and I hope you can appreciate that. I also
I appreciate it.
believe that you would find that they did not prove that I intended to steal a car, which is one of the later charges on this long list that they've put together. I believe you would find that it is a civil matter, and that when two people are married, they commonly use each other's vehicles, even if they are separate.
Objection, Judge. Improper argument.
Again, I'll instruct Mr. Summers to limit your argument to the facts and the law that are applicable to this case.
Gentlemen, I assert that utilizing cars while married is a civil matter. I also don't argue other issues. I ask you to just be favorable in understanding my position here. I ask you to please be cautious in understanding what burden of proof the state has to provide and how high that threshold is. That you cannot have doubts about these
It's getting lower, yeah.
They are very serious.
Objection, Judge. Misstatement of the law.
I will instruct the jury that, again, what Mr. Summers says is not the law. You will hear the definition of reasonable doubt when I instruct you on that law.
And so, gentlemen, reasonable doubt, I believe, is everywhere. And I ask you to please remember that and to please focus on
Reasonable doubt's everywhere.
that
I'm
element
control
that
finding it.
has to be proven by the time that you make these decisions about my life, about the situation that you've been presented, about deciding whether or not to find me innocent or guilty. I ask you to please consider all of these factors and see that what I am trying to show you is that this was a very abnormal series of events, and it requires a lot more information for you to draw a conclusion that would say that I absolutely am guilty of these crimes. And so for all of these reasons, gentlemen, I thank you for your time. I thank you for giving me the opportunity to explain this to you and to share with you a better understanding of putting it together. Thank you for allowing me to paint a little bit better of a picture, and I do appreciate your time, and I value your opinion on this. And I do.
I bet you
to
do.
Please find me innocent of the charges against me, and to consider what else may be available to you as you are instructed by the judge. Thank you. Thank you, gentlemen.
Well, that was something.
Mr.
10 out of
Johnson,
10.
rebuttal from the state.
10 out of 10. Best closing. Not guilty across the board, Mike.
My favorite bad arguments. She bullied me. I committed breaking and entering with benevolent intent.
Mhm.
And yes, you pointed this one out. She always had an opportunity to escape. There we go.
Yes.
Just don't even do a rebuttal.
Yeah, why even bother? Why even bother? Yeah.
She better have that machete somewhere. Because I want that. That was fun in the Deb trial. Bring me the blade. Bring me the blade.
Bring me the machete. She's loading a video.
Oh, here are the
That'd be perfect too, because she's not very big. So like the
Yeah, what
knife,
you got?
I mean, the machete would look all huge.
Uh-huh.
2 was attempted murder with the rope. Count 3 kidnapping, 4 sexual battery, 5 sexual battery, 6, 7, 8, and 9 are child neglect. 10 is grand theft motor vehicle, and then 11 is domestic violence injunction, violation of that.
Because there was a restraining order?
Yes.
Okay, yeah, hey, that's a problem.
Counsel.
How much time do you want to
Members of the
spend
jury.
arguing over counts 1 and 2? That's the only question in my mind.
Okay, Art and Landon. I need to give you guys some information. and I want you to make sure you understand this. I spent a lot of time with Mom the last few hours, and the things that she's told you about me being good at manipulation, control, and lying is true.
Good.
And tied her up.
I am a manipulator
That
and a liar.
is Trevor Summers in a nutshell.
Wow.
Manipulative, lying.
I am a manipulative liar. I'm really good at it
controlling.
too.
And Elisa Mathewson finally had the opportunity to stand up to him on that witness stand this week. She finally got the opportunity to stand up for herself and tell you exactly what happened on March 11th, March 12th, and March 13th. The defendant chose to represent himself, and that you have a special instruction in which to consider that. You are not to base your decision because you feel sorry for him, because you dislike him, or because you like him. You are to base your decision upon the law and the facts and evidence that have been introduced during this trial. The same goes for any witness that took the witness stand and the attorneys in this case. You must not make any decision in this case because you like or dislike anyone. It must be based solely upon the evidence and the law and the facts in this case. I'm going to touch upon some arguments made by the defendant a few moments ago. He said that there were no dents, no glass broken, no blood at the home. Did Miss Mathewson ever describe the incident of her being pulled from the bed by her feet and taken into the family room? Did she ever describe it in a manner that you would expect to find broken glass, blood, dents in the walls? No. She described it that he pulled her from the bed from her feet. She was throwing items at him, and then he guided her out into the family room, and she kept trying to get up and try to run out that door. That's what she told you. So I would submit to you that the photographs that were taken on March 12th of 2017 of her home clearly depict what had occurred. They corroborate what she told you had occurred in that family room. We see the pillows nicely aligned on the sofa that she was laying on earlier that night watching the Storks movie with Brennan Grady. The pillows are put on the couch in a neatly fashion. Look at the photograph of the way the pillows are on the couch that she tells you that she kept trying to run from the defendant on. They're all on the ground. He says, look at the fact that the cup and the Kleenex aren't where they were. She said she threw them. What do we know about what happened in that room? We know Brennan Grady were in that room after they were told to go back in the room, after the defendant told them to go back in that room and not come out. We know they were in there for some time, worried about their mom, yelling to their mom, "Are you okay, Mom?" And she yells back, "Everything's fine." Could they have picked up the cup and put it on the countertop, picked up the Kleenex box? We know that Miss Mathewson and the defendant were in that room for hours on the 11th. Is it unreasonable to think at some point when he walked in the room to tie her up multiple times, he picked it up, picked the Kleenex box up? No. He said that she was not tied when he went to Walgreens. Why would he take his estranged wife to go see the children for one last time tied up? The problem with him making that argument is that in his recorded post-Miranda interview, he says that he tied her up. So he's arguing moments
So there's that.
ago that he didn't tie her up to go to Walgreens, yet in his post-Miranda admission, he told the law enforcement officers he tied her up. He
That
said,
solves a lot of problems.
I
So
said, should
that's
I
why we didn't
tie,
test it
tie
for the
your,
DNA,
at least
'cause
tie
we
your
do.
hand so you don't,
That solves that
you know,
problem.
you don't do anything dumb in the car. He tied her up. Talks about the blisters, the blisters that, why would she go walking in this area, or this area was high brush, high dense area, and that's how she got those blisters. And then he was like, well, why didn't you wear flip-flops if you already had the blisters from being tied up? And she explained it. He said they were out in the woods. She described this as a high, densely brush area. And she was not going to wear flip-flops to walk through this, on this journey that he was going to make her go on to go find water. Is that unreasonable? He says in the video that he made that he was being nice and asking her what else he should include in that video. You don't see her in that video. She's not a happy woman who just had sex with the love of her life, wrapping her arms around his shoulders on that video. She's hogtied, laying down. That's why you don't see her in that video. He talks about the Walgreens video.
I do.
He wants you to go back and watch that video. I'd recommend that you go back and watch it, because what you're going to see is you see him walking into the store. He goes out of camera for a minute. He comes back in the angle of the camera looking out into the parking lot. And soon thereafter, he realizes that Miss Mathewson had managed to escape from the car while tied up. And he walks out of the store, and if you keep watching the video, he then proceeds to start running after her. And Mr. Crosby testified that he saw the defendant come from the store running to Miss Mathewson. Grabs her. That's how Mr. Crosby describes the interaction. Grabs her and takes her back to the car after she was yelling, "Please help, call the police." If that's not kidnapping, what is?
Yeah, it's a problem, Tim.
Why would he park in front of the store if he had tied her up and she was going with him unwillingly? You heard Miss Mathewson explain over and over again. She was with him for 16 years. She placated for him. She did what she had to do, so there was not conflict. She did what she had to do on March 11th, 12th, and 13th to stay alive. She was staying on his good side. She was going to do what she needed to do to make sure she stayed alive. That's exactly what she was doing this entire time. And it was finally on the witness stand this week that she was not going to placate him anymore. She was not going to go along with what he said. And she stood up for herself. The McDonald's video is a classic example of what their marriage was for 16 years, of her going along with what he said. He had threatened her before they went through the drive-thru, if you do anything, I'm going to hurt you. So what did she do? She did what she had done the last 16 years and just went along. She knew she had to do that to stay alive. He argues to you, if she could have gotten out of the car, I wouldn't have been able to get out of the car. My door would have hit the building. He was in the car. He could have run her over with the car. He had already tried to suffocate her one time. What would stop him from stepping on that pedal and running right into her if she tried to flee? She tried to flee one time. Remember, she tried to flee on March on March 11th at the Walgreens. She tried and she was unsuccessful. So she knew from that point on, she had to just go along with what he said until there was another opportunity, or until she was going to be able to convince him to let her go. Watch the Sitco video again. What did she tell you about what happened when they were at the Sitco? She was required to go back to the third row because he knew that the last time he left her in the vehicle, she had tried to run away. So she had to go into the third row and watch the video. Watch his demeanor and his actions in that video. He couldn't grab that dip fast enough from the employer or the employee there at the Sitco. He didn't wait for his change. He goes to proceed to walk out, and then he remembers he wants to get a newspaper because why? He probably wants to find out if people are writing about what had happened, the kidnapping of Miss Mathewson, because he had been listening and looking for it on the radio. So he gets the newspaper again. He doesn't even want to hand the newspaper over for the Sitco employee to scan it. The employee almost has to grab it from him to be able to scan it. He throws his money down again and he leaves. And the entire time that he is standing at the countertop, he is looking out the window for Miss Mathewson. Going back for a moment to Mr. Crosby, he says that he didn't know the make and model of the vehicle. He was more concerned about the license plate. Well, what's more important to give to law enforcement? Is it more important to get the make and the model of the vehicle or the license plate? And he is the most independent, non-biased witness in this case. And recall his testimony. He saw her with her hands tied behind, saw her hands with behind her back, running, yelling for help, call the police. And then the defendant, who he can identify, grabbed the victim and put her in the car. He talks about Kimberly Shea, and that she described during cross-examination that she thought possibly maybe her hand was resting up on the door, and that she looked distressed. And Miss Shea, 5.5 years later, the first time she's saying about the hand on the window was through the Zoom testimony, 5.5 years later. She told you she gave a very detailed written statement that included descriptions of both the male and the female, what she observed, the car. But that one statement of hers was not in that written statement. But he wants you to hold on to that so tight. But what we already know from his statement and Miss Matthewson's statement and Mr. Crosby's statement is her hands were tied. Because in the interview with Sergeant Remia, he admits that he tied her hands up so she wouldn't do anything dumb.
Yep, those admissions, man.
Why
Don't
would he have
talk
to
to the
tie her
police,
hands
man.
up if she had agreed to go with him?
Every word you say, man.
Let's talk about his interview for a minute, because he keeps harping on the fact of the medication that he was provided, that Hillsborough County Sheriff's Office didn't follow proper procedure in interviewing an individual in the hospital, that his statement was not knowing and voluntarily made. The state would submit to you that that 37-minute recording speaks for itself. He was provided fentanyl at 12:18. What did Dr. Chesla tell us about fentanyl? It is fast on and fast off. It quickly relieves people of pain, and it quickly wears off. We know that there were other drugs prescribed because they generally give nurses options for different pain management. But he told you that looking at the list, none of them had been given other than the fentanyl. None of the other drugs had been given to him. And listen to his recording again. He is clear. He makes sense. He does the majority of the talking. He says, this is just the cliff notes. I can provide more details if you want them. Those are his statements. He's not saying, I can't talk right now. I'm in so much pain. I don't understand the questions you are asking me. Can you come back? None of those things come out of his mouth. He could not been clear on the facts and circumstances surrounding what occurred those last 2.5 days. The DNA. There was no DNA linked to the sex battery kit of Miss Mathewson, of the defendant's
Why would you
DNA.
need it?
Well, we know from the defendant's own statement that they had sex. The issue for you to resolve was it consensual or not?
I'm going to go with
So
no
the
on
fact
that one, Mike.
there's no DNA there. He didn't
I'm
argue
with you.
to you that they didn't have sex. What does that matter? The issue with regards to the sex is whether or not it was consensual. And the state would submit to you someone who sneaks in Miss Mathewson's home in the middle of the night, ties her up.
As long as it's not what, if any, I'll take just about anything at this point.
The sex was not consensual. It is not reasonable to believe that someone would consensually have sex with that man after he tied her up with scarves,
Or you can stop talking.
rope,
This was
Christmas
that
tree
man.
lights.
We'll stop.
And that's not all just coming from Miss Mathewson. It's his own statement. He tied her up with the Christmas tree lights. So what would the DNA results on the Christmas tree lights give you? He already tells
Nothing.
you that he had tied her up
Nothing.
with the Christmas tree lights. What else did we learn from the DNA from Miss Montgomery O'Neill? That if people shower, that's going to affect the DNA. If people go to the bathroom, that's going to affect the DNA. And if someone has a vasectomy, that could affect the threshold. But again, the state doesn't have to put the semen inside Miss Mathewson. He admitted in his own statement that they had sex. The issue is consent.
The issue is
He
how many
talks
years.
about that law enforcement did not follow up on the writings, that whether a house can be transferred via writing, that a car or bank accounts were the correct bank account numbers. The thing with that, ladies and gentlemen, the state would submit to you that he never intended for Miss Mathewson to have any of that stuff. If you look at the note to the children, that explains 100% what his intentions were. His intentions were to kill Miss Mathewson and himself. You decide what kind of letter that was. Miss Mathewson was never going to kill herself. All she wanted to do was get out of the situation alive and to be with her children. He never intended for her to ever get out of that car. So he's going to pretend like, I'm going to let you go as long as you don't call the police. And she's like, I promise you, I will not call the police if you leave me these things. But he was never going to let any of that happen. So he didn't care if it was a valid quitclaim deed or a valid surrender of his parental rights, because he knew all along what he was going to do. He knew all along that he was going to kill her. And he was going to kill himself because he was going to be watching his children from heaven. That was his plan all along. He wrote those letters when they had arrived on the Anna Maria Island. They had pulled off. This is coming from Miss Mathewson and his own statement. That's when he wrote the letters. That's when he wrote the confession letter. That's when he wrote the letter of the surrender of the parental rights. That's when he wrote all of these letters, including the letter to the children. But Miss Mathewson never knew that letter to the children was written. She never saw that letter. He was never going to let her know he wrote that letter, because she would then know what the plan was. So he's driving around looking for this flag. That's what he told her. He was driving around trying to get up the courage to do what he knew he was going to do all along. He was trying to find the right place, but he didn't find the right place at Anna Marie Island. So then he moves along to Little Harbor. And that's when he had enough courage, he was going to handle it. He was going to kill her then. That's when he got in the third row and he took the rope around her neck and began to strangle her. And then he jumped in the car and fled because he saw an undercover vehicle. So these writings and the fact that law enforcement didn't follow up on them mean nothing, because to him, those writings meant nothing. He was never going to let her out of that car alive. He brought up Bryn and that her testimony contradicted Miss Mathewson's testimony. She was 7 years old when this happened. 7. What did she tell you, though? She told you that she saw scars on her dad. She told you that she was in fear for her mom. She was afraid for her. Is that contradictory of what Miss Mathewson told you? The defendant brought up the February 18 incident, and the judge read you a special instruction as to how you are to consider that evidence. And the state would submit to you that you must follow that instruction. And one of the ways that you can evaluate and consider that is to corroborate the victim. He talks about how Miss Mathewson can't remember conversations that they had for the 30 hours that they were in that car. What did she tell you? She told you that he can just talk and talk and talk about nonsense ad nauseum. Nonsense.
Yeah.
And he tries to act like that there was this big tumultuous arguing happening over these 30 hours. That's not what Miss Mathewson told you. She was playing along this entire time with him. There was no arguing. There was no tumultuous situation happening. There was no wrestling in the car. Look at the photographs in the car. Are there things strewn about that it would show that there was some kind of wrestling that he wanted to try to say that was happening in the car? And that's why she got those marks on her neck, because he doesn't want anybody to think that it could have been from him possibly strangling her. The nonsense. His statement, he says about the immigrants and that these boats, about these different times he was going to get these boats. Miss Mathewson was clear. Based upon things in their marriage over 16 years, there were reasons for her to believe what he was telling her. Miss Mathewson's vehicle was not a community vehicle. She left him. She moved into that home herself. She bought herself that car, and she had a job. That was not his car. That was her car. His car was the minivan that he decided to send his 14-year-old daughter in to drive the 12-year-old and 5-year-old and 7-year-old home. That was his vehicle. She didn't even know what kind of vehicle he had just gotten. There were no marital vehicles at this time. He had his vehicle and she had her vehicle. And she didn't give him permission at any time that weekend. to take her car. Everyone reacts to a traumatic event differently. There is no one formula or way that someone should react to a traumatic event right after the incident or 5.5 years later. This is not a situation where Miss Mathewson was kidnapped by a stranger. This was someone who she had been with since she was a teenager. For 16 years, she had been with him. So she knew what she needed to do to try to stay alive in that situation. And that's why she acted the way she did, why she acted to try and befriend him, to keep him calm, to try to not have conflict, because she knew after 16 years, that was the only way, the only chance she was going to ever have to possibly get out of this situation alive. The topic of a Baker Act was brought up during the testimony of the trial, but it's clear from the evidence and Sergeant Steele's testimony is that the defendant was never Baker Acted. He was booked in at the jail on the 14th. There was no 72-hour hold on him. He was in the jail the next day. Another thing to consider when he wants you to think that he is not of the right frame of mind when he is making his confession. But you don't have to just rely upon that confession. We have the written confession from him, and we have the videotaped confessions from him. He wasn't on fentanyl then. He wasn't suffering from his self-inflicted wound then. You have multiple admissions from the defendant. I want to take you through a few inconsistencies in his statements. He had told originally the victim that he had Miss Mathewson, that he and law enforcement was the purpose of going in there was to say goodbye. He was going to say goodbye in the middle of the night. He needed to sneak into her home to say goodbye. But then he tells his 14-year-old and 12-year-old that the reason he needs their help to get into the home is to address legal issues, and that he was going to convince Miss Mathewson to come home so they could be a family again. Let's talk about the wrist cutting situation, because Miss Mathewson was clear in her testimony that he cut her wrist because he was mad that she had tried to flee from the Walgreens. And it was done intentionally and purposefully. In his recorded statement, he tells law enforcement that he cut her wrist accidentally when he was cutting the rope. Well, let's look at the evidence in the case. We have the back of Miss Mathewson's shirt. The way she wears that is you put your arms through it, it buttons down the front, and where all the blood is in the back. So what does that tell us? What it tells us is that her hands were tied behind her back. She was cut because he was mad that she had tried to flee at the Walgreens. And she bled all over the back of her shirt when her hands were still tied together. He never cut her when he cut the ropes off, because if he cut her when he cut the ropes off, the blood would be on the front of her. The blood would be on the front of her clothes. Miss Mathewson knew she would be hurt if she tried to fight again or if she tried to flee again. So she went along with him in order to make sure she didn't get injured. And that's exactly what she told you. The evidence in this case corroborates every witness and every detail Miss Mathewson has told you. He tells you in his recorded statement that he's dead tired, so he had to stop. He had to park and drive in those woods. He was dead tired. If he was dead tired, how can you believe his
I gotta
statement
bounce,
that
man.
the
I'll talk to
two
you
of
later.
them slept for hours earlier?
Thanks for coming by, Kurt. That was awesome.
Together.
No problem.
How did they sleep for hours after they had this consensual sex and then he be dead tired? He was dead tired because he was up for over 24 hours. There was no sleeping after this consensual sex. He was dead tired of having to tie her up multiple times and keep watch on her, trying to get into her phone, find out who she had been talking to. That's what he was dead tired from. If you listen to his recorded statement, he almost makes a slip up and talks about this letter that he discusses that he and Miss Matthewson are going to watch the children from heaven. When he starts talking to the Sergeant Remia about the letters that he wrote, he says, drove all the way into Anna Maria. Right before Anna Maria, there's a boat ramp. We parked, sunlight starting to come up, and she wanted me to write some things. And she said if I did that, she wouldn't tell the police anything. So I wrote out, that she can have the house, car, the money, and whatever I left. Just said and then she wanted me to write, no, she didn't want me to write that. He almost said that he wrote the letter to the kids when he was talking to law enforcement, but he knew he couldn't admit to that because his whole floating over, not discussing the strangulation in that post-Miranda interview would be shot out of the water. He almost confessed to that, but he caught himself because he knew some of his story wouldn't make any sense anymore. He thought he was going to be able to get away with explaining the suffocation of the pillow as a pure accident, a joke. He was just being an ass. But he doesn't even mention the strangulation. He doesn't mention the strangulation because he knew he wasn't going to be able to cover that up once they had found that letter to the children. So he purposefully leaves that out of his statement. It's not a defense. The fact that your estranged wife joins a dating app, that's not a defense to any of these crimes. The fact that she's dating a man that she's now married to, not a defense to the crimes. The fact that she agreed to go with him at one point and changed her mind, not a defense to the crimes. The fact that she has sex with him and is dating other people, not a defense to these crimes. The fact that he wasn't right in the head, needed to go away, not a defense to these crimes. This isn't an insanity case. None of the reasons he gave Sergeant Remia in his confession are defenses to any of these crimes. The state has the burden to prove this case to you beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. What does abiding conviction mean? Abiding meaning firm, conviction meaning belief. If you have a firm belief that the defendant committed these crimes, you must find him guilty of those crimes. He had made the decision that If he couldn't have her, no one would, or no one could. And all of the evidence in this case corroborates each and every single witness that the state has put forth to you. I briefly want to touch upon the aggravation with regards to a weapon when it comes to counts 1 and 2, because the state has charged him with attempted first-degree murder with a weapon. The weapon in count 1 is the pillow. The weapon in count 2 is the rope. The definition for a weapon is 1, any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that was used, threatened to be used, attempted to be used, or intended to be used to inflict bodily harm. He took that pillow and put it over Miss Mathewson's face, pushed down with all of his weight until she wasn't struggling anymore. He used that pillow in a manner that could be used to inflict bodily harm. Therefore, it was a weapon. The rope. He took it around her neck from behind. The only reason he wasn't successful was because she had her hands tied this way and was able to catch the rope, prevent it from going around the front part of her neck. That rope was used in a way that could have inflicted bodily harm. The state would submit to you, we have proven that the pillow and the rope are considered and are weapons on the March 11th date and on the March 13th date. The facts in this case are almost unbelievable. But with the mountain of evidence that the state has proven to you, has given to you for you to look at and review, tells you exactly what happened and tells you that the facts are not unbelievable, that they are as stated. They are fact, the state would submit to you. The mountain of evidence, the overwhelming evidence in this case points directly to the guilt of Trevor Summers. And we're confident that at the conclusion of this case, you will find him guilty as to each and every count. Thank you.
Gentlemen of the jury, we're going to take a short break. I'm going to give my court reporter at least a little break before I read the instructions to you. There'll also be an opportunity for you to stretch your legs, use the restroom if necessary. It will be a short break. We'll come in and I will read you the final instructions, and then you will return to the jury room to deliberate. Please do not discuss the case amongst yourselves with anyone else. Please do not do any research related to the case. All rise for the jury. Mia, about how much time do you think you need? 5 minutes. All right. Well, we'll take at least 5 minutes. What I want the parties to do is look through now, because you've had some opportunity, but I don't know how much opportunity you've had to flip through the stack that you were provided before closing arguments, which is the changes that we discussed. Before I read to the jury, I'll ask each side to verify that the stack that with the changes is appropriate before I read it. So we'll take a short break. Thank you all.
Well, there you have it. I thought that was very good. Interesting arguments. He did a little better than I expected. I thought the prosecution did fine. I thought the first one did a nice, competent, straight job. She could work on uh, dramatics and that sort of thing. But I think she did a nice job. And I think the second one was more dramatic in her delivery and really had it put together. So this is interesting. Okay, so I was wondering if John was going to do that. So look, I'm going to hang out. Hopefully he comes out and has something to say to us. That is awesome. That is awesome. I was wondering, I couldn't see him, and then he said he went over to the other side because he was trying to get a look at the jury. So I'll be interested to hear what he has to say. So with this, I don't know. What I think I'm going to do is I'm going to hang out and see if John shows up for sure for a couple of minutes here, and then I think I'm going to let it go because they're going to read instructions, then probably take a lunch break. So what I'm going to do is after I talk to John, probably I'm going to close this down, and then I'm just going to be on standby for verdict watch. So I plan on going live when they come back to read the verdict. I have no idea, of course, but I would guess that will be this afternoon. And I'm just gonna leave it around so as soon as I get alerted, I'll come back on because that'll be fun. And I think I'll just do this as a separate stream. Otherwise, I think we're just gonna sit around for 2-3 hours waiting for a verdict to come back. I'm not particularly interested in the jury instructions. It was kind of neat to watch them hash them out this morning, but if you thought that was long, this will be shorter. But all they're going to do is read the very instructions that they went through this morning to the jury. I don't think that'll be particularly interesting. Then let them go to eat lunch and then deliberate. And then when the jury comes back, then that's what they'll do. So let me see here. I guess I should put this up just in case something happens there, but I doubt anything too interesting will happen there. We'll just have our time on there. Oh, here we go. Hello. I see you, but we're frozen up right now. Oh shoot! It's always hard to pull this off of the phone. John's here. I can see him, but his screen's frozen, and you guys can't see him at all. Let me see if he comes on. Come on, John. Come on, Wi-Fi gods. I want to hear what he has to say about the jury. Oh, thank you. I'm just kind of waiting for him to pop on. I mean, we're just having Wi-Fi issues here. Agreed. I thought the prosecution did a really nice job on both ends of the closing and closed really strong. John, how you doing, buddy? Oh, you got to get some signal somewhere. I want to hear. I'm chomping at the bit. Yeah, my preliminary reading. I thought that the attempted murder was the questionable one, but he did. I think he's guilty on all counts. That's my guess. If he gets an NG, it'd be on it'd be reasonable doubt on the attempted murder, but the other stuff he just flat confessed. I don't see how a jury goes any other way. Of course they can, but I just don't see how you can justify that. Well, I believe those are recommendations to John, but I want to get him on with picture, but that may not be possible. I imagine he's running around looking for better signal somewhere. All right, let me see here. Where are we now? I think that might be the problem. I think you might have Wi-Fi on, and if you turn it off, you're better off with just straight phone signal under the circumstance. I mean, who knows? Who knows? He might just not have good signal either. He's in the middle of Tampa, but you know that's it's always just depends on the circumstances of the moment. My Wi-Fi here is good most of the time, but every once in a while it's just nothing. Oh, come on, John. Let me see. Oh, I thought I got a message from him, but I didn't. All right. Well, that was something. And Trevor Summers there, his closing was just miserable. But we expected that. I feel a little cheated that we didn't get him to testify, but honestly, it would have been the same thing. You know, he wouldn't have said anything. It would have been fun to see him eat the convictions, but the convictions weren't that great. It looks like he had four prior misdemeanors involving dishonesty. But nobody's really believing this guy's credibility anyway. It would have been nice to see him have to deal with that. But that's where we are. All right, John, come on. Yeah, I don't know if I can call him. Let me see. It's not a bad idea. Let me see if I can just get John on. I'm just trying to get him because I want to. That was so cool of John to do that. Like I said, we hatched this plan last night, and I'm talking late. That we hatched this plan. I didn't think he'd do it, but that really did make it a lot more fun. I don't know. John may have gone back in too. That's a possibility.
We can take time, but we can take time to do that after I read and they go back. That's usually how we do it. And Mr. Summers will also get the opportunity to take a look at all the evidence before it goes back. No, I would start with 3.1, the substantive instructions that I'm about to give.
Okay.
Mr. Summers, so when I said I'm going to tell them in the beginning these instructions to go back with them, but it's the instructions that I'm going to read now, not those other things like that one I just read about the attorneys about to give or the parties about to give their closing arguments. It'll be these pages 14 through 58, and I will take the verdict form out. I will explain to them when I get to it that I'm going to remove it from the pack. I'm going to put a paper clip in it, and I'm going to place it on the top of the set of instructions. Okay. All right, let's get the jury.
I don't see John in there. I wouldn't. Unless it's him back left, but I don't think so.
Yes, we are.
All right, you're visible.
Jury is present and seated. Everyone else may be seated this time. Gentlemen of the jury, welcome back. First thing that I want to tell you before I read you the instructions is that these instructions will go back into the jury room with you. So this actual copy that I am reading from will then be sent into the jury room with you, and you will have them available to you during your deliberations. I mentioned that they are lengthy. It's going to be pages 14 through 58 that I'm going to be reading to you. I do apologize for reading to you, but they are written by the Florida Supreme Court. Every word of them is important. I'm going to also go ahead and turn my microphone on at this time so they don't have to scream the whole time that I'm reading them. If at any time for some reason you can't hear me, please just raise your hand and let me know. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions that I am about to give you. Trevor Stephen Summers, the defendant in this case, has been accused of the crimes of attempted murder in the first degree with a weapon, kidnapping, sexual battery by a person 18 or older upon a victim 18 or older, child neglect, grand theft motor vehicle, and violation of domestic violence injunction. Trevor Stephen Summers is accused of attempted murder in the first degree with a weapon in counts 1 and 2. Attempted first-degree murder includes the lesser crimes of attempted second-degree and attempted manslaughter by act, all of which are forms of attempted homicide and all of which are unlawful. However, let me just go back and read because I just noticed a typo and I'm just going to correct that by rereading it. Attempted first-degree murder includes the lesser crimes of attempted second-degree murder and attempted manslaughter by act, of which are forms of attempted homicide and all of which are unlawful. However, an attempted homicide that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find that there was an attempted homicide of Elisa Summers by Trevor Stephen Summers, you will then consider the circumstances surrounding the attempted homicide in deciding whether it was attempted first-degree murder or attempted second-degree murder or attempted manslaughter by act, or whether the attempted homicide was excusable or resulted from the justifiable use of deadly force. An attempted homicide is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the attempted homicide. An attempted homicide is excusable and therefore lawful under any one of the three following circumstances. Number one, when the attempted homicide is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or two, when the attempted homicide occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or three, when the attempted homicide is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the attempted killing is not done in a cruel and unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Trevor Summers may be found guilty of attempted first-degree murder. To prove the crime of attempted first-degree murder, premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. And this is as to counts 1 and counts 2. Number 1, Trevor Stephen Summers did some act intended to cause the death of Elisa Summers that went beyond just thinking or talking about it. Number 2, Trevor Stephen Summers acted with a premeditated design to kill Elisa Summers. Number 3, the act would have resulted in the death of Elisa Summers except that someone prevented Trevor Summers from killing Elisa Summers or he failed to do so. A premeditated design to kill means that there was a conscious decision to kill. The decision must be present in the mind at the time the act was committed. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the act. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the act was committed. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the attempted killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the attempted killing. An issue in this case is whether Trevor Stephen Summers did not act with a premeditated design to kill, because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that constituted the attempt to cause death, and Trevor Stephen Summers was, in fact, so provoked and did not cool off before he committed the act that constituted the attempt to cause the death of Elisa Summers. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should not find him guilty of attempted first-degree premeditated murder. If you find that Trevor Stephen Summers committed attempted first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of attempted first-degree murder with a weapon. A weapon is defined as 1, any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that was used, threatened to be used, attempted to be used, or intended to be used to inflict bodily harm. If you find that Trevor Stephen Summers committed attempted first-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of attempted first-degree murder. To prove the crime of kidnapping, this is as to count 3, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers forcibly, secretly, or by threat confined, abducted, or imprisoned Elisa Summers against her will. Number 2, Trevor Stephen Summers had no lawful authority to do so. Number 3, Trevor Stephen Summers acted with intent to commit or facilitate the commission of grand theft motor vehicle. See definition of grand theft motor vehicle, which is later in the instructions under count 10. In order to be kidnapping, the confinement, abduction, or imprisonment A, must not be slight, inconsequential, or merely incidental to the grand theft motor vehicle. B, must not be of the kind inherent in the nature of the grand theft motor vehicle. And C, must have some significance independent of the grand theft motor vehicle in that it makes the grand theft motor vehicle substantially easier of commission or substantially lessens the risk of detection. Secretly means the defendant intended to isolate or insulate Elisa Summers from meaningful contact or meaningful communication with the public. This is as to count 4 and 5. To prove the crime of sexual battery, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers committed an act upon Elisa Summers in which the sexual organ of Trevor Stephen Summers penetrated or had union with the vagina of Elisa Summers. Number 2, Trevor Stephen Summers' act was committed without the consent of Elisa Summers. Number 3, at the time of the offense, Elisa Summers was 18 years of age or older. Number 4, at the time of the offense, Trevor Stephen Summers was 18 years of age or older. Consent means intelligent, knowing, and voluntary consent and does not include coerced submission. Consent does not mean the failure by the alleged victim to offer physical resistance to the offender. Union means contact. Elisa Summers' lack of chastity is not a defense to the crime charged. To prove the crime of neglect of a child, this is as to count 6. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers willfully or by culpable negligence failed or omitted to provide S. with the care, supervision, and services necessary to maintain S. physical or mental health. Number 2, Trevor Stephen Summers was a caregiver for S. Number 3, S. was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult, household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. This is as to count 7. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers willfully or by culpable negligence failed or omitted to provide S. with the care, supervision, and services necessary to maintain S. physical or mental health. Number 2, Trevor Stephen Summers was a caregiver for S. Number 3, S. was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult, household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. I know it's redundant, I apologize, but each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. This is as to count 8. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. Number 1 is Trevor Stephen Summers willfully or by culpable negligence failed or omitted to provide B period S period with the care, supervision, and services to maintain B period S period's physical or mental health. Number 2, Trevor Stephen Summers was a caregiver for B period S period. Number 3, B period S period was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. This is as to count 9. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers willfully or by culpable negligence failed or omitted to provide G period S period with the care, supervision, and services necessary to maintain G period S period's physical or mental health. Number 2, Trevor Stephen Summers was a caregiver for G period S period. Number 3, G period S period was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or a substantial risk of death to a child. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. I will now define what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable negligence, it must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. This is as to count 10. To prove the crime of theft, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Trevor Stephen Summers knowingly and unlawfully obtained or used or endeavored to obtain or use the motor vehicle of Elisa Summers. Number 2, he did so with intent to either temporarily or permanently deprive Elisa Summers of her right to the property or any benefit from it, or appropriate the property of Lisa Summers to his own use or to the use of any person not entitled to it. Motor vehicle means an automobile, motorcycle, truck, trailer, semi-trailer, truck, tractor, and semi-trailer combination, or any other vehicle operated on the roads of this state used to transport persons or property and propelled by power and other than muscular power. But the term does not include traction engines, road rollers, motorized scooters, micro mobility devices, personal delivery devices, mobile carriers, special mobile equipment, vehicles that run only upon a track, bicycles, electric bicycles, swamp buggies, or mopeds. Obtains or uses means any manner of A, taking or exercising control over property, B, making any unauthorized use, disposition, or transfer of property, C, obtaining property by fraud, willful misrepresentation of a future act, or false promise, D, conduct previously known as stealing, larceny, purloining, abstracting, embezzlement, misapplication, misappropriation, conversion, or obtaining property or obtaining money or property by false pretenses, fraud, deception, or other conduct similar in nature. Endeavor means to attempt or try. It is a defense to the charge of theft if Trevor Stephen Summers had an honest, good faith belief that he had the right to possess the motor vehicle of Elisa Summers. If you have a reasonable doubt about whether Trevor Stephen Summers had an honest, good faith belief, even though unreasonable or mistaken, that he had the right to possess the motor vehicle of Elisa Summers, you should find him not guilty of theft. If you find the state proved beyond a reasonable doubt the defendant did not have an honest, good faith belief that he had the right to possess the motor vehicle of Elisa Summers, you should find him guilty if all the other elements of theft have been proven beyond a reasonable doubt. This is as to count 11. To prove the crime of violation of an injunction for protection against domestic violence, the state must prove the following two elements beyond a reasonable doubt. Number one, a temporary or final injunction for protection against domestic violence was issued by a court against Trevor Stephen Summers for the benefit of Elisa Summers. Number two, Trevor Stephen Summers willfully violated the injunction by committing an act of domestic violence. Willfully means knowingly, intentionally, and purposely. Domestic violence means any assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any criminal offense resulting in physical injury or death of one family or household member by another family or household member. Family or household members means spouses, former spouses, persons related by blood or marriage, persons who are presently residing together as if a family or who have resided together in the past as if a family, and persons who are parents of a child in common regardless of whether they have been married. With the exception of persons who have a child in common, the family or household members must be currently residing or have in the past resided together in the same single dwelling unit. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proven against beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of attempted first-degree murder are attempted second-degree murder, attempted manslaughter, attempted aggravated battery, and attempted battery. The lesser crime indicated in the definition of kidnapping is false imprisonment. The lesser crime indicated in the definition of sexual battery is battery. The lesser crime indicated in the definition of child neglect is culpable negligence. Next is an instruction that is titled 6.1 Introduction to Attempted Homicide. And then there's a note that says, please refer to instruction 6.1, which was previously given and read to you earlier in the stack. Next is to prove the crime. This is the lesser as to counts 1 and 2. To prove the crime of attempted second-degree murder, the state must prove the following two elements beyond a reasonable doubt. Number one, Trevor Stephen Summers intentionally committed an act which would have resulted in the death of Elisa Summers, except that someone prevented Trevor Summers from killing Elisa Summers, or he failed to do so. Number 2, the act was imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and 2, is done with ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Trevor Stephen Summers did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that would have resulted in death, and Trevor Stephen Summers was in fact so provoked and did not cool off before he committed the act that would have resulted in the death of Elisa Summers. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion on adequate provocation, you should not find him guilty of attempted second-degree murder. This is also as to lessers counts 1 and 2. If you find that Trevor Stephen Summers committed attempted second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of attempted second-degree murder with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2.
Okay,
any other
I think
object
John's on his way
used
out of the
to use,
courthouse
attempted to use,
to
or
chat with
attempted
us.
to use to inflict bodily harm. I'm sorry, Mia. Am I going too fast? Thanks. If you find that Trevor Stephen Summers committed attempted second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of attempted second-degree murder. To prove, this is lesser as to counts 1 and 2 also. To prove the crime of attempted manslaughter by act, the state must prove the following element beyond a reasonable doubt. Trevor Stephen Summers intentionally committed an act which would have resulted in the death of Elisa Summers, except that someone prevented Trevor Stephen Summers from killing Elisa Summers, or he failed to do so. However, the defendant cannot be guilty of attempted manslaughter by act by committing a merely negligent act. Every person has a duty to act reasonably and use ordinary care towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of attempted manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act which would have caused death and was not justifiable or excusable attempted homicide, as I have previously instructed you. This is also as to lessers count 1 and 2. If you find that Trevor Stephen Summers committed attempted manslaughter by act, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of attempted manslaughter by act with a weapon. A weapon is defined as, number 1, any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that was used, threatened to be used, attempted to be used, or intended to be used to inflict bodily harm. If you find that Trevor Stephen Summers committed attempted manslaughter by act, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of attempted manslaughter by act. This is also as to counts 1 and 2. To prove the crime of attempted aggravated battery, the state must
This is
prove
what
the
a jury
following
gets
two
every
elements
time.
beyond a reasonable doubt. Number 1, Trevor Stephen Summers did some act toward committing the crime of aggravated battery that went beyond just thinking or talking about it. Number 2, he would have committed the crime except that someone prevented him from committing the crime of aggravated battery, or he failed. To prove the crime of aggravated battery, the state must prove the following two elements beyond a reasonable doubt. The first element is a definition of battery. Number 1, Trevor Stephen Summers actually and intentionally touched or struck Elisa Summers against her will or intentionally caused bodily harm to Elisa Summers. Number 2, Trevor Stephen Summers is in committing the battery intentionally or knowingly caused great bodily harm or permanent disability to Elisa Summers.
John, you
or
there, buddy?
used a deadly weapon. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. It is a defense to the crime of attempted aggravated battery if the defendant abandoned his attempt to commit the offense or otherwise prevented its commission under circumstances indicating a complete and voluntary renunciation of his criminal purpose. Renunciation is not complete and voluntary where the defendant failed to complete the crime because of an unanticipated difficulties, unexpected resistance, a decision to postpone the crime to another time, or circumstances known by the defendant that increased the probability of being apprehended. If you find the defendant proved by a preponderance of the evidence that he abandoned his attempt to commit the offense or otherwise prevented.
It knocked out my entire phone.
All right. We're about to go live here.
All right, ready to go.
Okay. Hello?
Hey, Mike, how are you?
Good. Can you guys hear us? I see you, John. So yeah. All right. So tell us what was going on in there.
So it was interesting. I mean, so you couldn't necessarily see me because I decided to move over to the defense side just so I can get a better view of the jurors. I would say, from a practical perspective, I would not suggest there's a lot on the defense side. The entire time that they were sort of hearing the closing arguments, you could see multiple guys who had facial hair playing with their facial hair and just see it otherwise arms crossed, which is not a great sign for a defendant, generally speaking.
Right. So it is all guys. It is all male jurors.
So there's one I was not able to entirely be certain because of the distance. Might have been female based upon clothing, but was sort of androgynous looking, for lack of a better term.
Okay. So, and there are 6 of them, or are there any alternates?
So in Florida courts, anything outside of a capital case, there are going to be 6 jurors, and they usually have 2 alternates, and they did have 2 alternates.
What kind of age ranges are we looking at here? I mean, were they older, younger?
Frankly, I don't think I saw anybody over the age of 60, so it was somewhere in the ballpark, I would guess, of high 20s to maybe low 50s, high 40s.
Okay.
So a younger jury.
Were they listening to? Especially, I thought on the the rebuttal argument. Were they listening intently, or had they kind of cashed in and just they're done with the trial?
Yeah, it depended upon which one. Obviously, there was one gentleman that still had his notepad out and was taking notes very carefully during the course of the rebuttal argument. So, but I think they were paying attention. I don't think they necessarily kind of cashed out and gave up, but I think that they had a pretty decent idea of what they were going to do. And even frankly, during I called you before they finished the jury instructions, there were still some that were taking notes because I think that they were trying to be diligent, and that's one of the remarkable things about American juries is that they try to get it right.
Yeah, they really do. They really do. That's been my experience too. As cynical as we all get, you get these people in a room and they think, all right, well, let's do the best we can with it. I mean, that doesn't mean they're right or they know what they're doing or anything else, but generally speaking, they're earnest.
At least they try, and that's the best that you can expect. I mean, it's a citizen jury.
Yeah.
So they seemed, I mean, if you want kind of the racial breakdown,
yeah,
I think it was two black gentlemen, one who I couldn't necessarily place, I would think Native American, but I just don't know.
Sure.
And then the rest were white.
What was the vibe in the like I saw that was awesome. Like we could see everyone's like all excited and everything. But what was the vibe in the room, or was there anybody outside that not connected to the case aside from say you?
I do not believe so. I think it was entirely the alleged victim's family, the alternate public defender, and then me.
I mean that's what was wild when we were doing the Dep Heard. You were all over that with us, and when they were rolling in there, Rob and Ian and everybody, DUI guy, whatever. Like it was so hard to get in the courtroom, and you're like, how far is that from you? It's like maybe a couple miles from your place. I mean, I'm guessing from what I saw.
I could walk it in maybe 25 minutes.
Oh man. So you're like, okay, fine, I'll go over there. So like the hardest part was putting your suit on, like, okay, I got to look reasonable. I'm an attorney. I might actually end up in this room for some reason. I mean, you don't do criminal, but you never know.
I don't do criminal, but honestly, the toughest part is in New York, they give you an attorney's pass so you can skip security. So the toughest part was literally just waiting on the security line.
Right. Right. Well, yeah, but the thing is, when you're practicing, like I don't do this stuff either. But for instance, you could have one of your clients or whatever. You never know, and someone gets a DUI or something, and they're really close to you, and they want you involved. And you're like, oh God, I don't even do this, but okay, and you end up in any judge in the jurisdiction where you are. It may not be likely, but it's possible you might be in front of them.
Yeah, it's always possible, but that's why that's why I didn't decide to talk to really anybody,
right? And
just kind of kept decorum because who knows? I could be in front of this judge at some point.
Oh, absolutely, and I know because you do.
They cycle judges in Florida, so he could be doing a civil case tomorrow.
Absolutely, right. You do civil work, but he can get transferred over to a civil call next week, no problem. That happens all the time. It does in Cook County.
Well, I remember it in New York. They would literally have the old bingo rollers, and that's how they would pick judges.
Yeah,
it was a pain in the butt, but it is what it is.
Oh well, that's kind of fun. I imagine you're not going to sit around because I don't think that. What is your guess? Because you're the only one who saw him. What is your guess in terms of deliberation? I don't think this takes that long.
I don't think it's going to take that long. I mean, if it gets announced, I might stay in the area and get some lunch or something. But I can't imagine that it's going to be a long deliberation. I think the biggest issue is going to be the attempted murder charge, which I think Kurt actually addressed.
Right.
But the rest of the charges, when they started going down the charging instructions, I don't think I think there's a very unlikely proposition of them not finding the child endangerment charges, for instance.
Right.
So,
You know, it's bad because I literally did not know about this case until, you know, very, very recently. And then I did a thing which was from 2 days ago yesterday. And then I'm like, okay, this is interesting. So I just turned it on and started doing the trial from where it was. So I did miss a bunch. You know, I didn't see her direct examination. I didn't see that. Apparently these kids testified.
well, I didn't know a lot about it because it occurred 5 years ago. It was before I actually even moved to Tampa.
Yeah.
So I only started doing the research because we were talking about it, and I don't know. I don't want to speak out of turn or anything, but it's bad, Mike.
Yeah.
It's a really strange and bad circumstance.
Yeah, it is. How was the victim holding up? And I realize you're not going to sit there and leer at her. I get it. But like, did you get any sense? Because you were very close to her or whatever. Because that had to be some uncomfortable stuff they're reading.
I have to say, there was a period of time, or there were a couple of periods where she would step out and sit in the waiting room for a little bit with, I guess, one of the sons. I don't know.
Mm-hmm. Were his kids there?
I mean, certainly during the jury instruction conference, she was keeping herself together. I think during the closing arguments, she'd stepped out a couple times, but she seemed to be hanging in there.
Yeah, I mean, she really held up well on the stand, and it had to be just brutal to just this stuff. I mean, all of us can handle it, but who wants any of their stuff aired like that? Just for that.
I'm not sure I could have handled it half as well as she did.
Yeah, I mean, she was amazing in this thing.
If you went through this horrific episode,
yeah,
it's part of why. No. I don't necessarily agree with rape shield laws, but it's part of the reason why we have them.
Yeah. Well said. All right.
She handled herself brilliantly.
That is awesome. I still, everyone is like happy to. That's very cool. I'm glad you made it over there. Here's the deal. I'm gonna close down this stream. I was literally waiting for you. Because that's just really, really cool. Like I don't get a sense of this courthouse. Is this like a high rise or is this just like a regular court building? I can't tell.
No, so the courtroom is 51A. It's actually in the annex of the original courthouse.
Mm-hmm.
It's on the 5th floor.
Okay. But I mean, that was the thing too. Like I was back to the Johnny Depp. Like those guys had to sit and everything. You're just like, hey, I'll roll in here. It's close. Nobody asked you. Nobody's like, oh no, why are you going there to this high pro? Which is weird because it's getting coverage.
I was hoping he was going to testify today.
Oh yeah.
That was really why I showed up in the morning. And then when it became a pattern jury instruction, I'm amazed you were able to maintain the entertainment of the audience.
Yeah.
So that's good on you.
Well, John, we got law nerds, you know?
Yeah, that's true.
I mean, they can sit through a jury instruction conference for crying out loud.
that was incredible to me that you had, what was it, like 1,500 people sitting through a freaking jury instruction conference, which most lawyers don't want to do.
Yeah. Well, it also,
it's a heck of an audience.
It also helped that you were there, and it helped that Kurt came by.
Oh, absolutely.
So what I'm going to do is I'm just so you know, I'm going to close this down. I'm going to set up another stream and have it sitting ready. I'm just saying if you want to hop on, and then I'm just going to go. I'll send you a link, but I'm just going to go as soon as we hear that they're going to announce a verdict.
Yeah, I mean, I think from my perspective, I don't know if I'll be at the courthouse. I might stick around for an hour or so, grab some lunch,
right,
and head home. And whatever it is, I'll hop on.
Did you bump, like, are you ever in that building, that particular courthouse for your business?
Yes, I have been.
So were you running into your people today?
No, I was not running into my people today.
Yeah, because they're all on Zoom.
Most people on the civil docket don't particularly like scheduling things on Fridays.
Right. And even if they did, they'd be like, whatever. Yeah, he works. Yeah, like they wouldn't think anything of it.
But yeah,
They wouldn't.
So no, I did not run into anyone, but I have been through that courthouse a few times now. I mean, I was called to jury duty there about a month ago.
Ah.
I was not put on the jury. I was not even put in front of voir dire. But you know, that's kind of what happens when you write defense attorney on your occupation.
Yeah. Oh, yeah. I wouldn't let you near one of my juries. And you wouldn't let me near one of yours.
No, I would not. You know what my favorite thing in the med mal space is?
What's that?
If I could get a nurse on the jury.
Yeah.
That was my favorite thing on earth because, there was no special knowledge. It was just awesome. And
Yeah, but everyone will listen to him.
I'll let you go. And when they come back, I think they're going to come back today. I can't imagine them taking this weekends.
I think so too. So I'm gonna be ready to go. You feel free to hop on during, after, whatever. But that'll be probably a short stream. I'll just wait for him to come in and read a verdict. But I don't know when. I mean, that could be literally an hour from now. It could be 4 hours from now.
The only thing that's such a problem is because it's 11 charges, and there was at least one guy that throughout the entire reading of the jury instructions was taking notes. And that scares me a little bit in terms of a holdout juror.
Well, and you do get complexity. I mean, here's what can tie it up is all of a sudden, for instance, they decide like, oh yeah, guilty and everything, but somebody has a bug about one of them and they're like, well, we should do the lesser included offense instead or something, which is fine. But that can get into a big full-blown discussion and very intricate fast.
That's the only thing that I'm thinking in the back of my mind might make this a little bit longer, because to me, I think that you probably let him go on the first degree attempted murder. You probably take him on the second degree attempted murder, and the rest of them I think are just proven. That's
the way I see it.
That's the way I see it.
That's the way I see it. And if he could have shut his pie hole and had an attorney do it, he'd be out on the attempt all day long.
I agree with you, because I think that
because you can characterize it a different way or whatever. He's not out, especially not if you give those statements. He's not out on any of the rest. You can't argue around that when the guy goes and confesses it.
I don't think the state particularly effectively argued the intent elements.
Yeah.
And because he didn't take the stands, there's no way they can force him to argue the intent elements. So that one's tough to me.
Yeah. Oh, I'd be leaning hard on reasonable doubt with intent. That's your angle for sure.
Well, and the other thing that you would do as a competent attorney is, well, they charged him with these two things and try and make it cascade to put in the minds of the jurors that the other charges aren't satisfied either. And there is a way to kind of orchestrate that. You know what I'm talking about. But he just doesn't know how to do that.
No. No. All right, John. Thank you so much. It's made it so much more fun. I don't know why. Somebody said in the comments, and it's true. It's like since John's there, I feel like we're all there. You know what I mean? It's like in the house, we're represented, man. It's all good.
It's been my absolute pleasure, and hopefully we get a verdict today, and we'll talk again.
All right, sounds good. Talk to you later, John.
All right, take care.
All right, bye. Well, there you have it. That was so fun. Straight from the courthouse. John taking care of business, telling us about the jurors. So there were 6, 2 alternates. They all seem to be men. One seemed to be indeterminate, but he's just saying, I don't know, just from that distance. And yeah, it wasn't clear. But since the judge kept saying gentlemen of the jury, I would presume that it is a man. I don't know. It doesn't really much matter, but that's the way I piece it together. And the judge not only has more information in it, but is much closer. So I think that's why otherwise I think it would be sort of offensive. And that judge seems very conscientious and cognizant of these sorts of things. So I don't think he would loosely say gentlemen of the jury and exclude somebody. That's just the sense that I get. So there you have it. What I'm gonna close this one down. Thank you all for coming out. This was awesome. I am just going to somebody message me or whatever. I mean, I'm gonna be looking myself, but I'm just gonna be waiting for that, and I'm gonna flip it back on. I'll set up a stream, and it might even say that, and I'll just have it ready to go. And then when I hear that it's going, then to bring the jury back, I'll do a stream for the reading of the verdict, because that's always kind of fun. All right. Thanks a lot. I will see you all soon.